Yes.
It is the consent of the appellate at explanation and 6. In this case, senior counsel Mr. T. Mojumdar is appearing. There is some person can it be on
He
Friday
appears for whom?
on the respondent 1 to 6.
I am for the petitioner.
Okay.
Can it be possible on Friday?
Okay. A prayer for adjournment has been made on behalf of Sri D. Mazumdar, Learned Senior Counsel, who appears for the petitioner.
Respondent number 1 to 6.
Respondent number
1 to
1 to 6. On request list on Friday?
Friday, no.
highly approved.
Date, huh?
On 7.
Petition, Lordship. With the consent of other side, I would like to mention item number 23, Lordship.
Yes.
Can it come on 18th, Lordship? Because we are filing on IA.
I am appearing for number 1. That is this way I petition for person pay out the let number the matter is not 11.
11th, already lots of matters are there, Lordship.
Then 12 plus
12.
Just a minute. 12th is.
12 Wednesday next.
Yes.
We'll have
Okay, Lordship.
On a request made on behalf of the insurance company, matter is adjourned to be listed on 12th, 12 June
Obliged.
23.
May I please? My Lord, I am for item number 12, my.
Hmm.
The matter may be adjourned for that day.
For the day?
Yes. But
Okay. When do you want?
next week, my.
On a prayer made on behalf of the petitioner, at least after a week. 12. Yes.
Like-
Wait, please, Lord. May I pray for Lord indulgence for listing of an appeal, my Lord, against refusal of injunction, my Lord, on 3/6. We have filed it on yesterday, my Lord.
Fresh matter.
Press
When do you want?
tomorrow, my Lord. There is an urgency, my Lord.
Tomorrow, Thursday.
My Lord, a refusal of injunction, my
But when is the next date fixed?
Lord.
Why
No, it is-
tomorrow? We'll have it day after tomorrow. Friday.
can it be tomorrow, my Lord? There is an urgency. 3/6 it was refused. We filed it on yesterday, my Lord.
No, what is the urgency? Tell us.
My Lord, I may be dispossessed anytime, my Lord, from that.
No,
And my Lord,
dispossessed from where?
my Lord, I'm a tenant. Now,
On
what
the
hap-
basis of what?
my Lord, the landlord is trying to dispossess me. He has broke the lock. He has thrown some of my belongings outside. My Lord, it's a
If the injunction has been refused, in spite of these facts, what is the urgency? Tell
no,
us.
my Lord, it is an ex parte injunction, my Lord.
Ex parte has not been granted.
Not being granted.
So,
Notice was
Friday.
Right.
Yes.
Yeah, okay.
All right.
But in this case, madam, on 7th, madam, I will be evicted. There is the execution proceeding is going on, and the eviction will be conducted on 7th. So kindly tomorrow. I have filed it on 31/5.
Execution proceeding is going on, eviction on 7th. When did you file?
I filed on 31/5.
Not tomorrow, Friday.
But on 31/5, I have filed. Tomorrow, my lord, it will be better.
Why didn't you mention on Monday to have it today?
My lord,
Why are you waiting till today?
it was in the defection, my lord. So
So?
defect I have done.
Friday. Sorry.
May I please, Lordship? Lordship, I am appearing on behalf of Mr. A.K. Thakur, sir. He is unable to appear due to
Which matter? Item number
43 matter.
43.
Oh.
Yes.
He is unable to appear due to his father-in-law who was expired. So this
Okay.
matter may kindly be
Other
adjourned.
side? Have you informed the other side?
No, my lord.
Without informing, don't mention. Inform them. We'll accommodate.
My lord, I am just instruct.
You have to inform the other side, then you come to the court, not like this. Take consent, inform, then you come. We'll accommodate. Yes.
This high civil matter, for release of the 50% of the ordered amount. Let it be listed on 7th.
When did you file?
Day before it's yesterday.
Monday.
May it please, my Lord. My Lord, we beg to mention item number 19 with the consent of the other side.
Yes.
It may be listed any day on the next week, my Lord.
1921 matter. Yeah, for whom?
For the appellant, madam.
Appellant. Okay. On a prayer made on behalf of the appellant. List after a week.
If this is
Yes.
Pray for listing of a matrimonial appeal. The wife and minor child are
Fresh
deprived-
matter.
So it's a pending matter for admission. Pleadings are complete. We are deprived of maintenance. They have, the husband has challenged. They come up any day next week.
Okay, next Wednesday.
Appellate.
May I please the Lordship? But to a back to mention item number 50, the consent of
50.
50. Mr. D. Mazumdar is appearing for the respondent, not able to come.
Okay. When do you want?
On 13th, Lordship.
TK Engineering.
Yes, Lord, for the respondent.
Okay. Yes, other side.
Yes, well, I'm for the,
Yes, when do you want?
anytime.
On a prayer made on behalf of the respondents list after a week.
Much obliged.
Well, there is an interim.
Para, interim order passed earlier to continue till the next date of listing.
Much.
Obliged.
Application lawsuit. Your Honor, the matter has been amicably settled and the applicant wants to withdraw the case.
Your name?
A Metro.
A.
Metro.
Metro. 3A Metro Learned Council. For the appellant submits that there is instruction not to press this matter. Full stop para. The appeal is preferred against an order dated 9/6/2023 passed by the learned civil judge number 3 Kamrup M in so and so, miss case so and so, miss case number 947, miss J case यहाँ से देख लीजिए, हाँ 947 in title suit number so and so, by which the said case was dismissed. Full stop. The said application was filed for appointment of a receiver. Full stop para. In view of the aforesaid facts and circumstances and the instructions and the submissions made, comma, the appeal stands dismissed on withdrawal.
Lordship, the matrimonial appeal, your lordship, maintenance appeal, your lordship, and the petition was preferred against the order dated 2/5/23 of the miss case number 39 of 22 passed by the additional district judge Jorhat, and the whole matter is settled, your lordship. So you
Settled.
settled, your lordship. Additional affidavit has been filed and the deed of settlement is
Okay.
also enclosed there. Your lordship may grant the liberty to withdraw the matter, your lordship.
Okay. Mr. Sharma, you are for the
Sole respondent
Sole
on behalf
respondent.
of AK Sahib.
on behalf of?
AK Sahib.
Okay, okay. And you are Mr. Kashyap,
As such, yes.
heard Sri S. Kashyap, learned counsel for the petitioner. Also heard Sri N. Sharma,
HK Sahib.
H.K. Sharma, learned counsel, appearing on instruction of Sri A.K. Sahewala, learned counsel for the respondent. Full stop. Para. The instant petition was filed against and order dated 2/5/2023 regarding grant of maintenance and other expenses. Full stop. The learned counsel for the parties have, however, jointly informed this court that the matter has been settled out of court, has been settled amicably. Full stop. Sri Kashyap, the learned counsel for the petitioner, further submits that in view of such amicable settlement, comma, he has been instructed not to continue further with this proceeding. Full stop para. In view of the above, comma, the petition is dismissed on withdrawal.
Obliged.
May I please, your lordship? Lordship, I want to withdraw this petition, my lord, totally, but to file afresh.
Why do you want to withdraw?
Withdraw, my lord, in the sense that, my lord, being agreed by the order dated, my lord, 18/1/2024. Asked for the lot-
Had Sri T.U. Laskar, learned counsel for the petitioner, who has preferred this revision petition against an order dated 18/1/2024, granting ex parte injunction in Miss J case number 9 of 2023, in special case 15 of 2021, by the learned special tribunal, Nagaon,
Look.
full stop, para. The learned counsel, however, submits that he has been instructed to withdraw this petition, however, with liberty.
Right.
Full stop, para. Petition is accordingly dismissed on withdrawal with liberty as paid for.
Oblige, your lordship.
Wait, people up there. This is an application revision, my lord, whereby that application which I had filed under order 7, raising the plea of limitation, was rejected. Now, the facts of the case, so far as the pleaded case of the plaintiff, is that the predecessor in interest of the defendants, my lord,
You are the
I am the defendant in the suit.
petitioner is the defendant.
Petitioner is the defendant.
Suit for
Suit for specific performance of contract executed, said to be executed by the predecessor in interest of the defendant, the petitioners before this honorable court.
yes.
The case of the plaintiff is that on 8 December 2015, my lord, Ananta Kumar Das, who is not alive now, 8 December 2015, a sale deed was executed.
Sale deed.
Sorry, a sale
Agreement-
agreement was
Agreement to
executed,
sale.
to which I am not a party, nor am I a witness.
With whom? Predecessor of the defendant with whom?
My lord,
Sale agreement was,
the husband of the petition.
okay, then,
Now, during the lifetime of the executor, my lord, the plaintiffs, they had sent a legal notice to for specific performance on 11 July 2017.
11th,
July 2017. I'm not placing my case, my lord, I'm placing the case of the plaintiffs, because at this stage we have to go by the case of the plaintiff to be correct. And 11 July 2017, and he passed away on October 2017.
who passed away?
The executor of the sale agreement,
Legal notice was by whom?
Ananta Kumar Das.
The person who had executed this predecessor of the plaintiff,
Predecessor of the of the defendant.
of the defendant.
Yes.
Legal notice was by whom?
Legal notice was served by the plaintiff to the executor during his lifetime.
No, you have said the legal, the contract for sale
Sale.
agreement
Yes.
was entered into by whom?
Between Ananta Kumar Das and the plaintiff.
And the plaintiff.
Yes.
Who is Ananda Kumar Das?
The predecessor in interest of the defendant. The petitioner before this honorable court.
You said it was executed with the husband of the petitioner.
Yes.
What is the name of the plaintiff?
And the name of the plaintiff is Dhan Chaudhary and Dilip Das.
Two plaintiffs. Two plaintiffs.
Yes,
Dhan Chaudhary
and Dilip Das. They entered into a sale agreement with Ananta Kumar Das, husband of the petitioner before this honorable court.
Okay.
And while Ananta Kumar Das was alive, this Dhan Chaudhary and Dilip
Just a
Das.
minute, sir, a minute. Ananda. Ananda Kumar Das is your husband,
Yes,
husband of defendant.
husband of defendant.
Okay.
Now, while Ananta Kumar Das was alive,
Okay.
the plaintiffs, they sent a legal
Correct,
notice.
Correct.
for-
And October 17, your husband passed away.
Yes, and in July, they had sent the legal notice.
Yes. After
And now, after this, what I say, my lord, that 11 July 2017, they had already set the specific performance in motion. So that 11 July 2017 has to be the date taken for filing of the suit. They have filed the suit in 2022. Sorry, 2023
yes, title suit filed.
or 22. Yes, I'm correct. I'm sorry, my lord, 2020.
Hmm.
After 5 years of this legal notice.
Yes.
Now they are taking a plea in the plaint, my lord, if I may read, paragraph 9, page 60,
60.
60 of the additional affidavit, my lord. 60, the page is in continuation.
Paragraph 9. Yes.
Paragraph 9, page 60.
Yes.
That the plaintiff state that after the death of Ananta Kumar Das, in the previous paragraph, they have talked about the legal notice, so I'm not
Yes.
repeating.
Hmm.
That after the death of Ananta Kumar Das, the plaintiff on several times visited the defendant and disclosed that her husband during the lifetime had entered and executed a deed of agreement.
No,
for-
these are okay. Your application is under 711. You're taking limitation as a ground. Limitation can be a preliminary ground.
My
make
lord,
a-
on this,
Make a request for framing a preliminary issue. It will be decided.
my lord, that of course can be done.
Now, how limitation can come into the inbit of 711?
My lord, if I may just, I'm taking support of some Supreme Court judgments with
Please.
Raghavendra Sharan, 2020 16 SCC,
2000?
2020 16 SCC,
Yes.
601.
Yes.
My lord, on before I proceed with the judgment, my lord, on facts, I was just trying to impress one thing, that except that fact that they gave a notice in 11 July 2017.
Madam, let us assume that it is barred by limitation.
My lord.
Can limitation be a ground of within 711?
My lord,
Show us the
Supreme
law.
Court has held so,
Show
my
us the law.
my lord,
Let us have 711 first. Yes.
Rejection of
Yes.
plaint. The plaint shall be rejected in the following cases: where it does not disclose the cause of action, where the relief claimed is undervalued, this is not required.
Mm.
D, my lord, where the suit appears from the statement in the plaint to be barred by any law.
Now the question whether it's barred by the law of limitation has to be proved on facts.
My lord, if it is not if no dispute is there is no dispute raised,
How-
my lord, we relating
Now,
the
when
pleading.
when a plaintiff is presented for some relief, are you trying to project that they'll not dispute the point of limitation?
My lord, it's not the point of
Why will they come to the court if they think it is barred by limitation and they admit to it? You prove it, it's barred by
my lord,
limitation, matter ends.
just saying that it is not barred by limitation will not be
So
enough.
if you take a point of limitation, it is whose burden? Is it the burden of the plaintiff? Or it is your burden?
My lord, when the plaintiff pleads that there is no limitation, it has to prima facie make out a case that there is
So
no
that
use
has to
of
be
limitation.
proved, madam. Just simply saying your word of mouth and their word of mouth will go by,
Let
okay,
us go by the word of mouth of the plaintiff.
yes.
If the plaintiff is stating that there is no,
It
is-
can be a preliminary ground.
my
It
lord,
cannot be a ground of 7-11.
my lord, if we just go by the Supreme Court
Yes, yes, please, please.
decision, thereafter I will bow down, my lord.
Yes, yes. Which paragraph?
My lord, page 12, my lord, 6.2,
6.2. Yes.
my lord. While while considering the scope and ambit of the application under Order 7, Rule 11 of the CPC,
Yes.
few decisions of this court on this are required to be referred to and considered.
Yes.
In the case of T. Arivandam, 1997 4 STC, my lord, is
Yes,
already
yes.
referred to.
Yes,
While
yes.
considering the very same provision, that is Order 7, Rule 11 of TPC, and the decree of the trial court in considering such application, this court in para 5 has observed and held as under. We have not the slightest hesitation in condemning the petitioner for the gross abuse of the process of the
Now
court.
you show us that part where limitation can be a ground for rejection of a plaint under 7-11.
My court is considering 7-11, my.
We are obviously on 7-11.
Yes.
Show us that for the point of limitation, a plaint can be rejected by taking recourse to 7-11.
In my.
By taking recourse to 7-11, you have
Yes.
filed 7-11, rejection of plaint,
Yes.
on the ground that it is barred by limitation.
Yeah, that is what I'm trying to
Yes,
show, my.
show us where.
Paragraph, I was just reading my, on 7.3.
Yes, please, please. read.
My lord has taken Raghavendra Sharan 6 case,
Yes, yes.
page 12, 6.2.
Yes, where is it the point of limitation?
My lord, I'm just placing my lord.
Place it.
My lord.
We don't find any limitation point here. Madam, why don't you take the normal process, file an application, raise a preliminary issue, decide it first, get rid of the suit.
My lord, the Supreme Court has very clearly.
Please show us
categorically-
then, show
My-
us.
That is what I'm trying
Let
to
us
do, my
see.
lord.
Where
My-
is that very clear?
My lord, may
Dispo-
kindly bear up with me. My lord, if I may just, page, paragraph 7, page 16.
16.
16.
Yes, please.
Applying the law laid down by this court in the aforesaid decisions on exercise of powers under 7 Rule 11 CPC to the facts of the case in hand and the averment in the plain, we are.
Madam, but please don't waste our time like this. You may have the whole day.
My-
We don't have the whole day, sorry.
my-
Is there any point of limitation?
This is the paragraph which deals with
Please,
limitation.
please point it out. Where? Point it out where? We have read the paragraph.
My lord, paragraph, page 17,
Yes, where?
the last sentence.
Yes,
my-
last sentence.
Therefore, considering, my lord has got it. Therefore, considering the averment in the plain and the bundle of facts.
Madam, we may have to impose cost for wasting time of the court.
Yeah, my lord will do it. If I'm unable to, my
Yes,
lord will
please,
do it.
please.
I'm conscious of the
Yes,
fact, my
yes,
lord.
yes.
Therefore, considering the averment in the plain and the bundle of facts stated in the plain, we are of the opinion that by clever drafting,
Yes.
the plaintiff has tried to bring the suit within the period of limitation, which otherwise is barred by law of limitation.
Okay,
My lord, if I place the facts,
yes.
it is very much similar to the facts of the plaintiff. Therefore, considering the decision of this court in T. Arivandam Supra, as stated above, and the suit is clearly barred by law of limitation, the plaint is required to be rejected in exercise of powers under Order 7, Rule 11 CPC. And my lord, if I place the judgment, my lord, I have several judgments, but this judgment deals with all aspects, my lord.
Okay.
In every judgment, it has said that even it should be nipped at the bud. And it should not be, my lord has accusing me for wasting time, my lord. The Honorable Supreme Court has said that a suit should not be allowed to proceed if it is prima facie, the plaintiff, it does not prima facie satisfy that it is not barred by limitation.
Yes.
And it is a wastage of judicial time, and therefore it has also asked the courts where the Supreme Court exercises superintendent's power to exercise this power so that judicial time is not wasted, my lord. I know that I
What,
can,
what was the plaint here? What was the default here in this case?
in this case, my lord, they have pleaded that there was a note, they sent a legal notice on 11 July 2017. If they have set the specific performance into motion on 11 July 2017,
Here the delay
Yes.
was, here the delay was 22 years.
my lord, it can be 22, in some cases it may be 16, in this case it is 5 years, my lord. My lord, how many years of limitation can be permitted? That my lord may hold, my lord, I have no problem with
No,
that.
the limitation, there is no question of court holding limitation. Limitation is prescribed by the, by law. We
Even
cannot say
I
that.
understood that, my lord, even I understand. So 11 July 2017, if they set it in motion and that is the pleaded case, then within 3 years they should have filed the suit, my lord. And they have not given any ground, they have not given any date. Other than that, they said that in 2022, they have sent us a legal notice, my lord. That is the only thing they are taking. But this 11 July 2017 notice which they have sent to the executor, they have not even said that they gave any notice about the sale deed. We
Let us
do
see, let us see,
not know
let
about
us
the
see.
sole deed.
Let us see 11, these legal notice 11/7,
My lord,
page 131.
page 139.
Yes, 131.
139.
11/7 is 131, I think. 131.
Page number, my lord, 139. Acha, there is one in 131 also. Because
131.
okay. Yes, my lord, all right. It is annexed twice. 11 July 2017 to
Yes.
Sri Ananta Kumar Das, subject legal notice to apply sale permission to execute sale deed and to hand over possession. And they give a reference of some irrevocable power of attorney. My clients state that by representing yourself as the absolute owner as well as possessor of plot number so and so, you had executed a registered irrevocable general power of attorney dated 8 December 2015 and a registered deed of agreement for sale dated 8 December 2015 in favor of my client to sell the aforesaid land at a total consideration of such and such, only out of which amount of rupees such and such was received by you on the day of execution of the said agreement, that is 8 December 2015, which was duly acknowledged by your client by signing on the said agreement. My client says that prior to the execution of the aforesaid agreement for sale, an irrevocable general power of attorney on 23/9/2014, you have received an amount of rupees such and such by signing money receipt in presence of witnesses, and thereafter again received rupees such and such from my client, which means against the aforesaid land, you have received an total amount of rupees such as such from my client. That is rupees 10 lakhs was received from before the execution of the aforesaid agreement for sale, and irrevocable general power of attorney, and rupees such and such was received on the day of execution of the agreement for sale. My client says that in spite of receiving the said notice from my client, till date,
Okay.
all
Heard. Is B as going learned counsel for the petitioner. Para, in terms of the order dated 15/5/2024, comma, the petitioner has filed an additional affidavit, which is on record, full stop. Para, the instant petition has been filed under Article 227 of the Constitution of India, read with 115 of the CPC, against an order dated 7/12/2023, passed by the learned civil judge Kamrup in J case number 243/2022, arising in title suit number 150 of 2022, full stop, by the aforesaid order, comma, the application filed by the petitioner under Order 7, Rule 11, read with 151 of the section 151 of the CPC has been rejected. Full stop. The principal ground in the application for rejection of the plaint was the ground of limitation. Full stop. Para. The learned trial court by the impugned order has held that limitation being a pure question of law and facts, comma, a mixed question of law and facts, comma, the prayer for rejection is not justified. Full stop. Para. The learned counsel for the petitioner has petitioner in support of her case has relied upon a judgment of the Honorable Supreme Court dated 13/3/2019, passed in Civil Appeal number 2960 of 2019, wherein the Honorable Supreme Court had also held limitation to be one of the grounds while considering an application under Order 7, Rule 11. Full stop. Para. Let notice be issued. Returnable on. Today is what? 5th. Can you serve Dusty, madam? Or returnable on, we'll have it before the vacation on 26th of June.
Right.
Let steps be taken for service of notice upon the respondents by registered post with AD. Full stop. Within 2 days from today, full stop. Steps are also required to be taken by Dusty Service, which is to be routed through the registry of this court and in the notice accompanying the Dusty, comma, the next date is to be clearly reflected. Prior to the next date, comma, the petitioner is required to file an affidavit in proof of such Dusty. Para. The learned counsel has prayed for an interim order. Full stop. Considering the facts and circumstances and in the interest of justice, comma, till the next date fixed. Further proceedings in Title 150 of 2022 shall remain stayed. Full stop. The aforesaid interim order, however, would be reconsidered on the next date.
I'm grateful.
I beg your pardon for not replying to your queries properly the last time.
Which item? Item number?
53 of the subject.
What is the item? What is the matter
It
about?
is an application under section 24 for this inter-district transfer of a domestic violence case filed in Boko.
Case is instituted where?
In Boko subdivisional court.
You're the
Wife.
petitioner is the wife.
The petitioner is the wife. They agree.
You instituted a DV proceeding.
Yes.
Where?
And it was instituted in 2019 itself, and the case has not progressed much because the respondent lives there and it doesn't appear much either.
Instituted DV proceeding at Boko.
At Boko.
Yes.
And the ground she is
What is the present stage?
actually no cross or anything has been done. It is on interim, and he is not also making the payments. So the
That is,
little
is
girl-
that the grievance? That is
No,
not the
the-
grievance.
that is not a grievance. The little girl, the minor child,
You have a minor child.
which she had
What is the
recovered,
age?
11,
Son or daughter?
daughter. She's really brilliant. So the mother moved her to a school in Guwahati. And through this institution of this DV case, he had recovered the custody of her daughter.
Daughter is where studying in Guwahati.
Guwahati, in Satgaon, area. I'm not sure about the school name of the school.
Then what has happened?
Then she's also studying, she's doing her MA, and she's trying to find some kind of a position in Guwahati.
Now, what is the transfer you're praying
So
for?
we are just praying for the transfer, both the respondent, because the respondent also lives in Hattigaon area and doesn't appear in the POCO court often. She is incurring much cost traveling up and down to POCO. So we just want it transferred to Kampur Metro.
From Boko
SDGM
to
Kamrup Metro. CGM court, Kampur Metro.
which power are you invoking? Is it an inter-district transfer?
Inter-district transfer.
Okay.
24(1)(a). Lord.
These proceedings are in the of civil nature.
Civil nature. The whole respondent is a quasi-civil. So there is some aspect of
Quasi-civil or quasi-criminal?
quasi-criminal, we could say. But most of the proceedings are civil in nature. Hence, the respondent is not made, it's not compulsory for the respondent to appear in every date. And whereas being the aggrieved, he is appearing on every date and not also getting the maintenance amount.
Any suit, appeal, or any proceeding. This is not a suit, this is not an appeal. Any
Just a
proceeding
transfer,
pending in any court subordinate to it. Will it be a civil transfer?
civil transfer. Under section 23 also, where the several courts having jurisdiction are subordinate to the same appellant court, and application under section 22 shall be made to the appellant court.
We are not the
But
appellate court.
No. But where such courts are subordinate to different appellant courts, but to the same high court, the application shall be made to the said high court.
But this is the civil proceeding.
It is. That's why it is filed in this manner. Although it is carried on in the CGM court.
How do you invoke the CPC for a matter in the CGM court? Do you have some rulings? For DV proceedings can be transferred
That
by.
is, at last time, in fact, that is what I was referring to. I was getting, I was going through the High Court rules. I couldn't find much because the last trial courts and first appellant subordinate courts was the management of these rules was passed in 2007. And it's been a long time.
Now, why
and-
don't you invoke provisions of the CRPC?
Because inter-district transfer within CRPC, otherwise I'll have to go to CPC, CRPC 5299. One case, one GR case, we have transferred, I mean, notice is issued for transfer to that, but that's a GR case. And this is civil in nature. So it is.
Is it a civil
filed
in
with the
nature?
civil- Yes,
Proceeding before the CJM.
yes. The DV case, although it is civil in nature, it is proceeded before the
Show
CJM.
some law that is the civil in nature.
I have a book. I beg your pardon. Left it in the car, my
No,
lord.
before we go
But
to
it's
the
civil in nature.
DV case, consequence of a DV case, is it civil case?
Yes, because it has custody, it has the matrimonial issues like maintenance, and it has, apart from the protection part, which is section 18.
No, show us some law.
Again, I'm a little unprepared on that side, my lord.
No, see, we
I'm
can
getting
go,
caught,
we,
I'm getting
we can
caught
go
in your
to the
questions.
facts, we can go to the facts first.
I can show enough law, but I'm again unprepared on that side.
You come on day after tomorrow.
Day after tomorrow, yes.
No, your prayer for transfer would be considered, but
I am, yes, and I would,
in exercise of appropriate jurisdiction.
I would be very happy to bring everything to your lordship court, because you know this area is highly neglected. If you fix the matter at 2, I can bring some of the things.
Just a minute. Just
Or
a minute.
after tomorrow.
Just a minute. Just a minute. Okay. Why can't you invoke 407 of the CRPC?
For the CRPC, but it's all conducted in the civil manner. And I have a judgment also of the High Court, but it's slightly unprepared.
No, how
This
can
which was transferred
will a
from-
CJM
transferred from
have a
the
civil
Dibrugarh to
proceeding?
Jorhat. CGM, because all the domestic violence cases are conducted under the CJM court.
Why? Why is it
within
not
the-
before the Munsif?
It's because it's within the act.
Act prescribed the CJM.
Acts,
It's a
the act
quasi-criminal. Why do you? How can you invoke
because the
24
protection order,
of the
because,
CPC?
because of the protection order.
What is the bar in invoking the jurisdiction under the criminal code of criminal procedure?
I think it's as a process, it's been done in this fact.
Not
In
show
several
us-
courts.
show us that
I-
by exercising 24 powers.
At 2, I'll bring
Yes.
everything at 2.
All at 2 o'clock.
Apply.
Item number?
May I please, your lordship? Lordship, in this case, the petitioner has filed this petition challenging the order passed by the learned court below on 5/4/2024 in title suit number 395/2023. Your lordship will find the impugn order at page number 121. Last page of this.
121.
Yes, your lordship.
Yes, what has happened?
Mayor, it looks third para from the perusal of the case records, it appears that the defendant has filed his written statement cum counter claim on 1/12/2023, and the plaintiff, despite being present, have not collected the service copies of the written statement cum counter claim filed by the defendant on subsequent date as well. It appears from the conduct of the plaintiff that the plaintiff had refrained from receiving the service copies despite being aware of the written statement cum counterclaim being filed on 1/1/2023. As such, in view of the conclusion of the statutory period of 90 days, is as counted from the date of filing of the written statement cum counterclaim by the defendant, the plaintiffs are precluded from filing any reply written statement to the counterclaim of the defendant. Now, your lordship may kindly come to page number 83. This is the my lordship interim order that was passed in the application file under order 39 rule 1 and 2. Thereafter, lordship, matter has been picked again on lordship 21/9/2023. Thereafter, lordship, in all occasions, lordship, the PO of the honorable court was on leave, lordship, from lordship 29 from 21/9/2023 up to Lordship 5/4/2024. Lordship, the plaintiff, defendant has filed his written statement on 1/12/2023. Your Lordship will find at page number 91.
Yes.
May I read, Lordship? PO is on leave.
No,
The
that we
plain-
have seen. 1/12/2023, the written statement as well as counterclaim was filed.
File, Lordship.
Okay.
On that day, Lordship, that on the subsequent that was fixed on 23/2/2024, Lordship.
Next date.
Next date, Lordship.
Okay.
On that day, Lordship, due to some fault of the counsel of the Lordship plaintiff or due to overlook, Lordship, that copy of the written statement was not Lordship seen in the that was tagged in the Lordship record, and it was the fault of the petitioner counsel of the plaintiff, Lordship, that he has not gone through the order passed by this honorable court, because on that day PO is on leave, Lordship. If Lordship, the plaintiff has received the copy of the Lordship written statement
Mr.
on
Sharma, you are appearing.
My, for
Yes.
respondent number 1.
You're the plaintiff. Or you're the
My
defendant.
lord,
You filed a counterclaim.
My-
Yes. What do you say?
My lord, the order, my lord, that I have filed the obvious and counterclaim, my lord, that is, my lord, very much available, my lord, in the e-court service. So they can, my lord, always.
No, we are not with Mr. Sharma. We are not with him. What do you say? We give him a chance to impose some cost.
But my lord, respondent number 2 also,
It is your counterclaim.
my counter. Just, my lord, I point out one thing, my lord, is they have filed the suit, my lord, for my lord declaration and for permanent injunction. We have DRT, my lord, tenant, my lord, and we have filed counterclaim for detachment and for realization.
When can you file your this written statement?
within 10 days.
File it within a week.
Yes.
We'll impose cost, some cost.
Conduct of the plaintiff, my lord.
No, we are
Yes,
not,
yes,
we are not in
yes.
appreciation, but we want these matters to come to an end. Otherwise, it will be pending here. Nobody will be gaining. Ultimately, the interest of justice will suffer. Okay. This is item number. Appellate. Or Sri D. Sharma, Learned Counsel for the, you're on caveat.
I am okay.
Your name is not there, Mrs. Sharma.
My lord, I have not received the copy, my lord. That's why, my lord, I have my name has not. Otherwise, in caveat, my lord, I have.
Okay.
It is first list, my lord, my name has not.
Heard Sri R. Sharma, Learned Counsel, caveat to be Learned Counsel, who has lodged this caveat in connection with an order dated 5/4/2024 passed by the learned civil judge, Junior Division number 3, Kamrup M, in TS 395 of 2023. Full stop, para. The caveat would be heard in the event this court proposes to pass an interim order. Para. Caveat stands discharged. In the main case, you write. Heard, Sri D. Sharma, Learned Counsel for the petitioners, who by means of this petition filed under Article 227 of the Constitution of India has put to challenge an order dated 5/4/2024 passed by the learned so-and-so, caveat dile hisila, in TS number so-and-so. Full stop. By the aforesaid order, comma, the petitioner, who are the plaintiffs, have been precluded from filing written statement to the counterclaim lodged by the defendants in the suit. Defendant number 1 in the suit, full stop. Para. Perusal of the, it transpires that against the plaint presented by the petitioner plaintiffs, comma, the defendant number 1 had filed the written statement on 1/12/2023 along with a counterclaim. Full stop. The next date was fixed on 23/2/2024 when, and even on the said date, copy of the written statement along with counterclaim was not collected by the plaintiffs. Full stop. When the matter had accordingly come up for consideration on 5/4/2024, the impugned order as narrated, as mentioned above, has been passed. Full stop. Para. Sri D. Sharma, the learned counsel for the petitioners, has submitted that though the counterclaim along with the written statement was filed on 1/12/2023, the learned counsel for the petitioners in the trial court was not aware of it. Full stop. On the next date, i.e. 23/2/2024, it is contended that the presiding officer was on leave, and due to inadvertence of the learned counsel, the copy of the written statement and counterclaim could not be collected. Full stop. Para. Sri R. Sharma, the learned counsel for the respondent defendant number 1, has however submitted that the period prescribed for filing written statement against the counterclaim being over, no fault can be attributed to the impugned order dated 5/4/2024, which has been passed strictly in accordance with law. Full stop. Para. The rival submissions have been duly considered. Full stop. This court is of the opinion that on principle, the order dated 5/4/2024 does not appear to be suffering from any legal infirmity. Full stop. At the same time, the period prescribed for filing written statement has been held to be directed in nature. Full stop. Of course, the said view has to be applied on case-to-case basis, as otherwise it will defeat the entire essence of the amendment to the Code of Civil Procedure, which was made for the objective of lessening the time consumed in disposal of a suit. Full stop. Para. In view of the aforesaid discussion, this court is of the considered opinion that interest of justice would be served if the petitioners, plaintiffs are given a chance to file the written statement against the counterclaim, for which this court deems that a period of 10 days would be sufficient. Full stop. The said liberty is, however, subject to payment of cost of ₹5,000 to be paid to the defendant number 1. Full stop. It is further made clear that if the written statement to the counterclaim is not filed within the period of 10 days from today, no further time will be granted.
Tomorrow is the date, next date.
You file it in 10 days.
Yes.
Can you file it tomorrow? File it tomorrow?
Within 10 days. Sir.
No, we are granting you 10 days. If it's ready, you can present it tomorrow. Petition is accordingly disposed of.
Okay.
Highly
এটা মনে করে দিবে ঠান্ডা আছে।
Wait, wait. But in the,
Yes,
I'm sorry, Lordship, that I pick up to item number 5, Lordship. I'm praying on behalf of T. Borkotopi, Lordship, that respondent number 5, Lordship, respondent number in item 5, Lordship. Taking time, Lordship, please could not come to court, Lordship, please start.
yes, Mr. Ganguly.
no, they have filed a reply in the contempt matter yesterday. ma'am. That perhaps may not be on record, but the CRP Malod is pending unnecessarily from 2019 on.
Okay, we'll have it together,
Sure.
maybe on Friday or Monday next.
Friday.
No,
Only
we'll
today-
accommodate Mr. Borkotoki.
For today, Malod.
He is having some difficulty, okay.
No issue.
Oh. This court has been informed that due to some personal difficulty, Sri T. Borkotoki, learned counsel for the respondent in the in contempt case number 227 of 2021 could not be available in the court today. Full stop. Heard Sri A. Ganguly, learned counsel for the petitioners. Full stop. Para. In the interest of justice, matters are adjourned to be listed on Friday or
Friday.
Monday?
Friday,
Friday, Mr. Manu? On
I'll
Friday.
inform him.
Friday.
there is an interim order in item 4. That
Interim order. Passed, if any, stands extended till the next date fixed.
Much obliged. Much.
In this case, some development that stood before the trial court is dismissed for default, and an application for restoration was filed.
You're
Next,
the plaintiff.
no, I am the defendant. The land grabbing case was land grabbing case.
Oh, your case was dismissed for default.
Default.
Then you'd filed an application.
Yeah, Lord.
Restored.
no,
No.
Malod. It's on 24/7.
Okay.
So
Now,
the-
what is your problem here? Why have you come here?
My written statement was not accepted, although ex parte order was vacated and next it was before framing it. Without written statement, you cannot be framed.
Now, suit has been dismissed.
The suit has been dismissed. Now it may, now I can, I'm praying.
If it is restored, you renew your prayer. We'll have this pending.
That is
Pending, yes, Lord. In first week of August.
First week of August.
Okay. The learned counsel for the parties have informed this court that the case filed under the Land Grabbing Act, from which, in connection with which the present petition has been filed, was dismissed for default
On 1/3/2000.
on 1/3/2024. And the application for restoration has been filed, which should come up for consideration
24th of September.
on 24?
24/7.
24/7/2024. Para. In the interest of justice, let this petition be adjourned to be listed in the first week of August.
Right.
On which date the further development may be apprised. Yes, 8.
Please, your lordship, my senior Mr. B. Chakraborty is on leave in another court. Kindly matter will be taken up with
Yes, Mr. Deka, what is this?
This is a second appeal. Subsection question, they have some certain substantial question of law that the Honorable Court number 17 has said that they are not the subsection of. So accordingly, I tend to file from a fresh substantial question. They have framed that also not the substantive question.
When can we have? Monday, Friday or Monday?
at 2, lordship.
Friday, Lord.
Friday we have fixed many matters. We can have
Monday, Lord.
Monday, or we can try at 2 o'clock. Then if
At 2 late to come.
at 2 o'clock.
Okay.
Item 9. Item 9. S.S. Sharma, L. Sharma, B. Mukherjee. Yes, Buragohai, Mukherjee, they are normally there. None appears for the appellants. Yes, Mr. Buragohai, yeah.
But in this case, your lordship, the dispute is among the family members. So some talk of settlement is going on.
Okay.
That will
Sri
be
H.
taken up.
Buragohai, learned counsel for the appellant, has submitted that the list is amongst the family members and some attempt is on for an amicable settlement. Full stop. He accordingly prays for and is granted 4 weeks' time to reach such amicable settlement. List
Obliged,
after
sir.
4 weeks. Item 10.
Wait, did you write?
Yes.
This is a regular second appeal against reversal. The appellant before your lordship was the plaintiff, and he filed the suit for declaration of right, title, and interest over the suit land and confirmation of position.
Appellant is the plaintiff.
Yes,
Suit for?
suit was for declaration of right, title, and interest over the suit land, confirmation of position, and permanent injunction, and also cancellation of the sale deeds, certain sale deeds. Now, case of the plaintiff was that he came to know that part of his land has been said to be has been mutated in the name of the private respondent. And when he made inquiries, he found that the land has been mutated in the name of the defendant on the basis of some sale deeds, which were supposed to have been, which were claimed to have been executed by the father of the plaintiff, and the plaintiff is also shown as an identifier in the sale deed. So he applied for all the certified copies, and thereafter he filed objection in the mutation case.
What is the parlance identifier?
He was an identifier in the sale deed.
Witness?
As witness.
Oh, not we didn't witness.
Witness, but they have in the evidence that's been stated to be as
Identifier. No, this we have not heard this.
Yes, he is a witness.
Witness.
So he did not have any knowledge. So his claim was that those sale deeds are
fraudulently executed. Okay.
Then eventually the suit was decreed.
In your favor?
In my favor. On appeal, the decree has been reversed on the ground that one is on the point of limitation.
In institution of the suit?
Yes, my lord. Limitation because the sale deeds were executed in 1984, 85 and 95.
1984,
1985 and 1995 allegedly by the father of the plaintiff, who died in 1998.
Okay.
And the defendant.
Your father had passed away in 1998.
1998.
Yes.
And the mutation was claimed in 2001. My case is that I came to know only after the mutation was made and I obtained the certified copies. But the first appellate court held that the sale deeds were executed in 84, 85, therefore this is time for.
Okay, mutation was in the year when did you execute when do you institute the suit?
My suit is of 2003.
2003?
Yes.
Suit is of 2003?
Yes.
And you also pray for confirmation of position?
Yes, ma'am.
That means you are in position?
Yes, ma'am.
So where is the question of limitation?
No, the question of limitation did not come, but the first appellate court held that. And another, my lord, finding is that.
No, apart from the fact that you claim to have knowledge much later at the time of maybe some activities whereby they tried to come into your land.
Yes.
Then how do you construe limitation? Can it be considered from the date of execution or from the date of
My
knowledge?
lord, the first appellate court has had the.
Was limitation discussed by the first court, trial court?
Yes, my lord, trial court also this.
There was
discussed-
an issue.
Yes, my
Definitely
lord,
there
that
was an
the
issue.
Issue, my lord.
Issue was answered in your favor.
This was
That
answered in my-
answer is in reverse now.
Yes, my.
And what is the next round?
The next ground is that although I claim that I was not the witness or identifier in the cell deed, but from the my lord evidence on record, he comes to a finding that I have admitted that I have knowledge of execution of the deed. That is a barbarous finding. And that's why, my lord, this honorable court-
In the cross examination, did you utter anything like this?
my lord, in the cross examination, it is not a fact that I know this, and it is not a fact that has been, my lord, ignored and said that you have got not. That is a perverse.
Can you show us that part?
Yes, my lord. No, in fact, my lord, I had also produced the copy of the evidence.
Evidence.
That should be on record because the court wanted to know that.
Yes, yes, yes.
That was the query. Okay, no.
You produce separately?
Yes, my lord. Produced separately because that was the query from the court. There your
Asani
lordship will
ke-
find
Asani, evidence. Evidence ki- No, it will be-
page 14, your lordship, I can take.
Of,
Page 14 of this, my lord, the evidence.
no, Asani, we don't have it here.
Just produced on the last date, my lord. Or my lord, I may produce this copy.
Huh? Can you show the bunch?
Yes.
No, if it's there, Susan, can you go down a bunch too?
Can you go?
এইটো ফার্স্ট উপরটো এখানে এইটো এভিডেন্সটা
That's what photo can put.
তাহলে
Or may I paste this?
if we have, we'll why should you give again? এখানে চাইলাম
In fact, my lord, perhaps.
Do you have an extra copy, Mr. Chaudhary?
Yes, my. Yes.
থাকিব লাগে তো এইটো নাই ন কেনেকুৱা চাই ফাৰ্ষ্ট পেজটো চাই ফাৰ্ষ্ট পেজটো চাই ফাৰ্ষ্ট পেজটো কোনো কথা নাই Yes, please read.
Page 14 is the relevant part.
1-4, yes. এইটো সত্য নহয় নেকি?
এইটো সত্য নহয় যে 8-11-95 তাৰিখে মোৰ পিতাই ইমান নম্বৰ ৰেজিষ্টাৰ দলিল যোগে উত্তৰীয় ডাগৰ 1 বিঘা মাটি দলিলত চহী কৰে। এইটো সত্য নহয় যে 20/85 তাৰিখে পিতা আলী চয়ন্ত 1 নম্বৰ বিবাদী নুৰুল ইছলামৰ গোচৰ পট্টাৰ দাগ নম্বৰ ইমানৰ ম্যাদী পট্টাৰ ইমান নম্বৰ দলিলে বিক্ৰী কৰিছিল।
Yes, let us see the finding. Let us have a look at the finding of the first appellate court on this.
That your lordship will find, my lord, at page 72. In fact, it starts at page 70, yes, my lord, 72, issue number 9 and 10.
72. Yes, please.
These two issues, in fact, my lord, issue number 9 and 10 are, issue number 9 is whether land measuring 3 bigha 2 katha has been purchased by defendant number 1, 2, 3, 4 and they are in possession. And number 10, whether defendants are bona fide purchaser with value without notice. So these two issues were discussed by the appellate court. These two issues are taken together for convenience.
Yes, at page 73, he disclosed.
Yes, my lord.
But in course of his cross-examination, he disclosed that he knows about the fact of execution of the sale deeds. I think this one.
Yes. I thought I have submitted the
Where is your question on the point of limitation?
This, my lord, limitation, I have not yet.
I think that should be the first question.
Right.
What is the issue?
Issue was, my lord, whether the exact sentence is
Issue number 3.
question
Issue number 3.
whether the suit is brought by limited.
Yes. Okay. Hard. Item number 10. Hard. 3. M.K. Chaudhary, London Senior Counsel, assisted by Sri Borkotoki, for the appellant who has referred this appeal the second appeal against a judgment dated 30/5/2016 and decree dated 2/6/2016. There was a limitation application of what earlier?
No.
Then why have you preferred now? It's a judgment
Yes.
limitation application. Okay.
Yes, no, that is important.
And decree dated 2/6/2016, passed by the, please have your seat, Mr. Chaudhary, passed by the additional district judge, FTC, Nagaon, in title appeal 2/15, full stop, by the impugned judgment, comma, the initial judgment and decree dated 2/2/2012, passed by the learned civil judge Nagaon in title suit number 87 of 2023, was reversed. Full stop. The suit was initially decreed in favor of the appellant plaintiff by the learned civil judge Nagaon in title suit number 87 of 2023. Full stop. Para. The learned senior counsel has submitted that at least on 2 counts, comma, the judgment of the first appellate court is not sustainable in law. Full stop. Para. Upon hearing, comma, the appeal is admitted on the following substantial questions of law. Number 1, whether the impugned judgment on the point of impugned judgment of the first appellate court on the point of limitation is in accordance with law. Full stop. Number 2, whether the findings of the first appellate court on the issue of fraudulent execution of the sale deeds are in accordance with law and in consonant and in accordance with the evidence on record. Full stop. Para. This court may frame any other substantial questions of law at the time of hearing. Full stop. Para. Let notice be issued. Don't say, let steps be taken for issuance of notice upon the respondents by usual process. Steps be taken within 2 days from today.
Highly okay.
Now, what is the stage now?
Correct.
Stage
Stage.
of the land.
There is the, we're in position and there is no execution.
That has not been executed.
It has not been no execution process is initiated for the peaceful position.
Okay.
And therefore there is no question of any stay. Also.
Made this one.
Yes.
But the regular second appeal back against concurrent.
This you can take it back, Mr. Chaudhary, Mr. Borkotogi. You can present it on the next date. Yes.
My lord will find the substantial questions of law at page number 12A. 12A. So the appellant, my lord, were the defendant.
You are the defendant.
Defendant.
Suit for?
Suit for
How many
declaration.
appellants?
Well, 4.
4 appellants. Defendants. Suit for?
Suit for declaration of right title interest, recovery of first possession, permanent injunction.
You have for recovery also.
I am the defendant's man.
Okay, recovery of cost.
First possession of the suit land
Yes.
and cancellation of mutation.
Of mutation. Okay.
Mutation. Of the in favor, which was passed in favor of the defense. Well, the case is like this fact. The suit land map that consists of around 11 bighas originally belonged to 2 Pattatars, Tahir Poromanik and Mokbul Hussain. The plaintiffs are the legal heirs of Tahir Poromanik.
Tahir and
Mokbul Hussain.
Mokbul.
Plaintiffs are the legal heirs of Tahir Poromanik.
Yes.
So their case is that Mokbul Hussain, during his lifetime, relinquished his share in favor of the predecessor of the plaintiff,
Tahir.
Tahir. And he died issueless. So thereafter, they claim that they have inherited the entire suit from their father. That is their case.
Okay.
Our case is that we purchased the entire suit from the original Pattatars, Tahir Poromanik and Mokbul Hussain, by virtue of unregistered deed back in the year 1978. And thereafter, in the year 1981, the ban was mutated in our favor.
On the
81.
basis of unregistered sale deed.
Yes, because the value was shown to be below 100.
Where do you get land? How much land?
11 big. That is our weakness, sir. Right?
What was the value?
Value was shown to be around 98 rupees.
98 rupees.
98. And in the cross-examination,
Which year?
70th.
Huh?
70th, 1970.
1970.
1970.
Not 1270.
No.
It should be
Yes,
during the
but-
Ahom
Yes,
period.
but in the cross-examination, my lord,
98 rupees.
yes. In the cross-examination, my lord, it was really propped up that the value was around 50 to 60 rupees per day. That was there in the cross-examination.
50 to 60 rupees.
Per day. That is there in the
Which
cross-examination.
place?
Borpeta district.
When was the transaction done?
It was shown to be 78.
78. You get 1 bigha at 70 rupees.
Yes.
Very good. Let us go to Borpeta today and explore.
So,
Then what had
Yes,
happened?
so the
But
thing is-
mutation was done.
yes, mutation was done in the year 1981. So, our case is that the plaintiff will have proved their case independently, irrespective of the weakness of the defendant's claim. Now, the plaintiff has claimed right title interest over the entire suit consisting of Tahir Poromanik's share and Mokbul Hussain's share. So, they will have to invariably prove that relinquishment, that 50% share they got from Mokbul
No,
Hussain.
but the mutation is put to challenge.
Mutation was not cancelled, though it was paid for cancellation. that has not been challenged by either the.
No, you said that they prayed for cancellation of mutation.
Cancellation, yes.
Yes.
But no such issue was framed and it has not been cancelled in the
So what has happened in the suit, trial court?
trial court decreed in favor of the plaintiff,
Okay.
declared right title interest and also recovery of past possession, but that relief regarding cancellation that has not been touched.
Hmm.
That was kept up. So our case is that the learned court ought to have seen whether the plaintiffs are entitled to right title interest over the entire suit consisting of Tahir Paramanik share as well as Mokbul Hussain share. That relinquishment deed was in fact
But you said that you had purchased from both the,
both the, yes,
was it a joint purchase?
yes.
Then how are you affected, whether it is relinquished or not?
No, but they will have to prove their
It
own
is not a
case.
separate sale deed that you purchase from Maqbul 1%, Tahir 1%. They were the joint
Yes,
property
but
holders.
the plaintiffs will have to establish their own case. But that has not been done so. They have admitted that it was on the basis of a relinquishment deed, but that relinquishment deed has not been proved. And the lower court hammered on the weakness of the defendant's court. So that is why, my lord, our substantial questions, my lord, if your lord will kindly see. Page
No,
number
suppose there is no relinquishment deed.
Yes,
And Tahir is not in dispute that Tahir and Maqbul are brothers.
yes,
They come from the same,
yes, but they are not brothers.
who are not brothers.
No,
You said they are brothers.
no. They are co-partners, not brothers.
How is Tahir connected to Maqbul?
No, my lord, that is not the pleaded case. If your lordship will see the plaint,
What is the name of the father of Maqbul?
your lordship will kindly see the plaint, my lord. It starts from page number 13,
1-3.
1 page.
Yes.
And the relevant paragraph is at page number 15, point number 2. Para number 2,
Page 13.
15, my lord. Relevant portion at page number 15.
Hmm.
Para number 2. Says that, my lord, the Pattada, Tahir Paramanik and Mokbul Hussain jointly enjoyed and possessed the student without any kind of interruption from any Pattadars as well as from any conduct.
Yes.
So their story is that they paid premium and by virtue of that they got patta. It is not their case that they were
Yeah, we have not filed any counterclaim challenging the Patta, their title. Their title was not in dispute.
No, we have admitted their title because we have basically
If you
Our
have admitted
claim-
their title,
our
their
claim, my
title
lord,
was not even with the
generated from their title.
was not even the issue before
Yes.
the court.
Yes,
Now, what are your substantial
yes.
questions?
At page number
No
12.
suit was decreed, then what is the, what
And my-
appellate court has confirmed the decree?
yes, and the next thing is that our mutation is from the year 1981. And mutation entries, my lord, are presumed to be genuine unless it has been shown to be illegally or fraudulently done. Now, if that is taken to be true, my lord, that the due notice was given to all these stakeholders, so they ought to have filed an appeal within a limited period. But they have come by filing this suit in the year 2015, whereas our mutation dates back to 1981. So if your lordship will kindly see the substantial questions of law at page number 12A.
Well, A.
12A.
Can you raise this in a second appeal? The question of relinquishment, was it an issue?
Yes, because they
Where is the issue? Let us see.
issues, my lord, are at page number 38.
3-8.
38.
Yes, please.
Whether there is a cause of action in the infringement suit, whether the suit is barred by any law of limitation or any other law, whether the plaintiff has right title interest over the suit. So the issue of relinquishment will come within this issue.
No,
that is
no, no.
number 6. Because they have prayed for declaration of right title interest
No,
over the
no,
entire
no.
suit.
Not in
On-
a second appeal.
On this
We
thing,
are
of-
not a suit, deciding a suit for the first time.
but if your lordship will see the
No, we'll not go to the issue of relinquishment at a second appellate stage. Validity of the relinquishment, unless you raise it as one of the preliminary grounds. There is no counterclaim, there is no defense to this respect. There is no issue framed. You never raised any objection regarding the
because-
issues.
because that can
You
be
cannot bring it.
decided
That will lead to a floodgate, that this issue will encompass everything. That is
Then-
not the purpose.
Sir, if your lordship will see, the impugned judgment at
The relinquishment, we cannot be.
page number
substituted.
78.
And mutation. When was the suit instituted? 2015.
2015.
And when did what was the averment regarding their knowledge? They have
They
recovery of
have
cust-
said that they have got the knowledge in the year 2015 itself, after we have allegedly trespassed into the land.
Then,
But they have not been able to show that why.
well, what is your take on the aspect of when did you take possession of the cast possession of the land in question?
17 itself,
2000?
1970.
19?
We are dependent. 1978 itself.
No, 1981, you said mutation
Yes.
was done.
Mutation was done in the year 1981, but delivery of possession was done in the year 1978 itself.
Let us see your written statement.
Yes.
Page
That's page number 25.
25.
25.
Yes.
Para number B.
B.
That the Pattada Tahir Poromanic and Mokbul Hussain for need of money proposed to sell the ex-scheduled land to the defendant number 1A, B, external defendant so agreed to purchase the land, 11 bika, 1 katha, 1 lessa of
Okay,
land.
we can have at best the third question.
Well.
Okay, third.
As-
Sorry, as thus learned counsel for the appellant, who by means of the second appeal has assailed the judgment and decree dated 19/2/2024 passed by the learned civil judge Borpeta in title appeal 11 of 2021, full stop, by the said judgment, comma, the initial judgment and decree dated 22/4/2021 passed by the learned civil judge junior division number 1 Borpeta in title suit 24 of 2015 has been affirmed. Full stop. Para, the learned counsel has submitted that the issue of relinquishment of the property by one Makbul, who was the joint patadar with the predecessor in interest of the plaintiffs, was not proved in accordance with law. Full stop. However, and accordingly, the substantial questions of law framed, draft substantial questions of law framed by the learned counsel was presented. Full stop. Para, this court has, however, noticed from the materials on record that such issue was not raised specifically, and therefore the learned courts below did not have the occasion to deal with it. Full stop. Para. In view of the above, comma, the substantial question of law is restricted only to the following question. Full stop. Para. No, substantial question of no. Accordingly, the appeal is admitted on the substantial question of law, which is as under number 3, page 12. Let steps be taken for service of notice upon the respondents by usual process. Steps within 2 days, list after 6 weeks, along with service report.
It was okay.
Let it be alive let them come, we'll see.
Highly open.
Item 13. 1-3. Yes, Mr.
May
Gupta,
please
what is this?
The feelings of the defendant, the suit. This sole respondent is a sole plaintiff.
Just a minute, please.
Okay.
Appellants are the defendants.
Appellants are the defendant in the suit.
8 appellants,
8 appellants before
defendants. So suit for
suit for confirmation of right title, interest, and recovery of first purchase.
confirmation and recovery. What is it?
Yes, Lordship, that is their confirmation of joint Lordship, because the plaintiff and the performer respondent.
Now, if you are praying for recovery, then what is the question of confirmation? Confirmation is
Declara-
something which is already in your possession.
Yes, they have sought for the declarations. Lordship, declaration that they came this suit land inherited from their father. Only one plaintiff has come. Rest of his brothers are the performer defendant. His claim is that it is partition, and he got his share of the suit land of 1 week. Then Lordship, we have the defendants have appeared and filed written statement as well as counterclaim. Defendant's case is that they purchased 5 acres of land, which includes the suit land, by registered sale deed. Thereafter, Lordship, unfortunately, the counsel for the defendant did not appear after filing of the written statement. And accordingly, Lordship, the suit proceeded ex parte, filed order dated 1916. 1916.
16.
Yes, 1916.
Yes.
Then Lordship suit was decreed ex parte. And in the suit, Lordship, title has
Decree,
been
decree expiry which date?
on 25/5/17.
5/17.
Yes, it was decreed.
Expiry decree.
Yes, on the basis of Rapsita and Domabandi, title has been set. There are our counterclaim was on the basis of a registered sale deed, but the expertise title was decided. Then Lordship, and title execution case was filed, and we came to know when they have come to the execute the decree. We came to know about the expertise decree on 5/4/18.
Yes.
Then Lordship, after that, certified copy was applied on 6/4/18, certified copy got on 23/4/18. And thereafter, an application under Order 9, Rule 13 was filed on 24/4/18, along with an application for condonation of delay. Then only
You
one.
file Order 9, Rule 13 application
Yes.
for setting aside
the
ex parte.
expertise decree. Along with that, one condonation application was filed, and a single miss case was registered, and that High Order dated 13/9/18, the learned Munshi 13/9/18.
Yes.
The learned Munshi dismissed that miss case.
Limitation.
Thing is that Lordship, this Order 9, Rule 13 was registered as a miss case, and the delay condonation was not registered, so miss case has been dismissed. Then Lordship, we have filed a miss appeal.
No, the dismissal was on the ground of limitation. Or
Limitation.
the prayer for limitation was not considered.
No. Then Lordship, we have filed a miss appeal number 1/18 before the civil judge Golaghat. That was also dismissed on 19/11/19.
You preferred miss appeal
2018 before the civil judge Golaghat, and it was dismissed on 19/11/19. Then against that order, CRP 39/2020 was filed before the Honorable High Court, and that was also dismissed on 21/3/20. Against
Okay.
that Lordship, SLP was filed for the Supreme Court, and it was also dismissed on 18/5/20.
23. So this proceeding has continued till 18/5/23.
Hmm.
Then Lordship, we have again applied for the certified copy, and within 5 days, Lordship, we have filed a regular title suit under section 96(2) after dismissal,
Challenging what?
challenging the ex parte degree on merit. Within 5 days, we have filed. Now, Lordship, that there is also a delay condonation application, Lordship, which is the case number 13/22, and that was also dismissed on 29/11/23. This is the impugn order. Now, Lordship,
Delay condemnation in what?
delay condonation is filing the title appeal.
No, not title appeal. You said that you had filed a fresh suit
No.
against the ex parte decree after dismissal of the SLP.
SLP was dismissed. This entire proceeding is under Order 9 Rule 13.
Correct.
Entire proceeding has ended on 18/5/23.
Correct.
Then we have filed title appeal.
Against the initial decree.
That decree.
Initial decree.
Yes, challenging
Okay,
on merit. It is permissible.
Okay,
Lordship.
yes, it's permissible, permissible.
And on the and this argument was made on the basis of one decision, Lordship, N. Mohan versus R. Mothu, 2020 SCC 302. And this has been quoted by in the impugn judgment. And Lordship, it was misinterpreted by the court below, Lord. If Lordship,
2020. But there was no bar for you to challenge the original decree at the time itself. You
that is elaborated, Lordship, in this.
you stuck on your application under Order 9 Rule 13.
Yes.
That was the decision on the condonation aspect.
Yes.
Delay condonation aspect. You lost. You came to the appellate court, lost. High court lost. Supreme Court lost.
Oh.
Original decree was not put to challenge on merit till now.
Yes. After dismissal,
Yes.
we have filed the title appeal under section 96(2). This is permissible, and what stage it can be done. This decision, Lordship, similar fact here. Here also, Lordship,
Paragraph
15 and 16, and this paragraph has been quoted in the impugn judgment at page 137.
Let us see paragraph 15 and 16.
Here, Lordship, the fact is similar. Here also, Order 9 Rule 13 condonation gone up to the Supreme Court. Then, Lordship, again they have filed a title appeal under section 92. And in that context, Lordship, it is discussed in paragraph 14 and all, Lordship, 15. I'm reading, Lordship. And it is quoted in the impugn judgment. The defendant against whom an ex parte decree is passed has two options. First option is to file an application under Order 9 Rule 13 CPC. And the second option is to file an appeal under section 96 to CPC. The question to be considered is whether two options are exercised simultaneously.
Mr. Dhaka,
yes.
The dismissal order of 29/11/2023, is it on the count of maintainability or is it on the ground of delimitation?
Limited.
So that this decision will not be relevant at this stage.
Because
see, you have come to this court
yes.
questioning the order of dismissal of 29/11/2023,
yes.
which is primarily on the aspect of limitation.
Limited.
We'll examine that, but the availability of the option to file an independent appeal on merits is still open. That is there is no dispute.
Yes. Only thing is that here, Lordship, because there is only within 5 days we have filed the appeal. And Lordship, if Lordship see the paragraph 16, near Plexitum G,
yes.
It says the court, in case the court is satisfied that the defendant has adopted dilatory tactics or where there is a lack of bona fide, the court may decline to condone the delay in filing the first appeal under section 96(2) CPC. But where the defendant has been pursuing the remedy bona fide under Order 9 Rule 13 CPC, if
Yes.
the court
Yes,
refuses
yes,
to condone the
let-
delay,
yes, yes, these are clear. Let us see the impugned order.
yes, Lordship will find that relevant portion, Lordship, at page 135.
135.
Yes. That all things are discussed, Lordship, whatever I have stated, Lordship, the case. Then 136, Lordship. It says that 136, Lordship, that from the alleged knowledge, there has been total 481 days. And it is says that the petitioner defendant were illiterate rustic village having no proper understanding about the
14 page
case 136.
136.
136. Here says that Lordship, the order passed ex parte until knowledge total 481 days. Then Lordship, that the petitioner defendant were illiterate rustic villager having no proper understanding about the day-to-day procedure of the court. The reason is regarding their delay from 28/4/18 to 18/5/23 was that they were being busy in 4 different forums. This forum. The condonation of delay of so and so in fact falls during the period when the proceeding under Order 9 Rule 13 CPC was pending in different forums. Now, Lordship, this paragraph 15 and 16 has been quoted in the next page at page 3,
Yes, yes.
137. Now, Lordship, here, after quoting this paragraph in 139, page 139, that again 146 days, that it says the non-appearance of the defendant during the period of trial before the court of Munship number 1 Golaghat was
Okay,
not.
where are your substantive questions?
Yes, Lordship, at page 11, Lordship.
11.
That ground I.
Heard. Sri J. Decker, Learned Counsel for the appellants who has referred this second appeal against an order dated 29/11/2023 passed in Ms. J, case number 13 of 2023, arising out of title appeal number 1 of 2023 by the learned civil judge, Senior Division, Golaghat. Full stop. The aforesaid order has been passed by which the application filed under Section 5 of the Limitation Act 1963 has been rejected. Full stop. The title appeal was referred against the judgment and decree dated 25/5/2017,
7.
passed by the learned
Munship number 1.
Munship number 1 Golaghat, entitled suit number
7/2015.
7/2015. Para. The learned counsel has submitted that the appellants who were the defendants in the suit had initially exercised their options for vacation of the ex parte decree by filing applications under Order 9, Rule 13 of the CPC and kept on pursuing till the stage of the Honorable Supreme Court. Full stop. However, not being successful in the attempt, comma, they have chosen to file an appeal against the original decree on merits, which was done within 5 days from the date of dismissal of the SLP by the Honorable Supreme Court on 18/5/2023. Full stop. It is also submitted that the learned First Appellate Court had misconstrued the law regarding the point of limitation and has also ignored and also overlooked the observations made by the Honorable Supreme Court in the case of N. Mohan versus R. Madhu, reported in 2020, 20 SCC 302, wherein the aspect of bona fide has been highlighted in pursuing their legal remedy. First para. The appeal is admitted on the following substantial questions of law. Page 11, huh? One and two. Let steps be taken for service of notice upon the sole respondent by usual process. Steps be taken, usual process within 2 days. List after 6 weeks, along with service report.
Deeply obliged.
Yes.
The appellants are the plaintiff.
Hmm.
In this case, suit was for partition. Suit decreed that First Appellate Court reversed that decree.
Just a minute. Appellants, how many appellants?
Lordship, 4 appellants.
They are the plaintiffs.
Yes,
Suit for?
suit for partition.
Okay.
And Lordship, after trial, suit was decreed, then First Appellate Court reversed Lordship. Then
Suit was
we-
decreed in your favor.
Yes, sir.
Okay.
And thereafter, we preferred one RS 64 of
Just a minute.
2003.
Suit was decreed. First Appellate Court reversed.
Yes, sir. That is the first round of litigation. But thereafter, RSA was also preferred.
You preferred RSA?
Yes, sir. RSA 64 of 2000,
RSA 64 of
2003.
2003.
Yes,
Then what happened there?
that was Lordship, page 42, 43, relevant portion Lordship. There was a direction given to decide 3 points by the trial court. Again, it was remanded for
By
press
this court?
Yes.
Order of remand?
Yes.
Dated?
dated 22/5/2014.
On 3 points?
Yes. Whether plaintiff has any title whatsoever to the property left behind by Bhagwan Das, and if so, whether he can make a claim of partition of his share, whether there was any amicable partition to the property left behind by Bhagwan Das in any point of time.
Yes, the remand was to the trial court or the First Appellate Court?
Trial court.
Trial court?
Yes. Then trial court decreed to partly decreed. Point number 3 is what is the quantum of share of each of the legal heirs of late Bhagwan Das on the basis of the law holding the field.
Suit partly decreed. Then?
Yes. Then we preferred first appeal as because we are not satisfied with the share given to the plaintiff. So first appellate court lordship partly modified the judgment of the trial court.
Hmm.
In the trial court, we have taken a stand that one of the legal heir of Bhagavan Das, Mohanlal, he died issueless, and he already
Now, what are your substantial question?
that is page 5.
5.
Yes, sir. Whether the judgment and decree passed by the both the learned courts are correct in accordance with the direction of the remand order.
That
As
is not
per
a
remand order, lordship, they are not deciding.
That is not a substantial question of.
Lordship. And point number 3 was not decided in accordance with law.
These are not substantial question. You have to frame a question.
Regarding share, we are not satisfied. Lordship. So these are the substantial question of law regarding share order. A remand order also clearly says if we are entitled for our share from the property of Bhagwan Das lordship, our share may be.
Madam, we have to properly assess
Then
the
your
court.
lordship can admit this on substantial question number 4. And because the entire property, share and property of all the legal heirs.
It's a very vague substantial question. This cannot be construed to be a substantial. You read what you have drafted, whether the findings so arrived by the courts on various points are in accordance with the pleadings.
Yes, but if the
How can
pleadings
this
and
need to be
lordship
very
evidence-
specific? You frame a question. We will accordingly will you
that
assess the
regarding
court by
regarding share lordship, we are already not satisfied. So the point number 3 and 1 lordship, we are not satisfied. So I have written that the findings.
Let
so
us see
arrived-
point number 1 and 3.
Point number 3 decided by trial court, page 55.
Now let us see the points.
Page 50.
50.
Yes, by the trial court.
50. Okay.
These are the points framed by the High Court.
The plaintiff has an elaborate title. The quantum of share of each of the legal. One, why you should be aggrieved?
Yes.
Your question, you will not question your own title. I think 3.
3.
One says
For
that whether
that lordship, the substantive question of number 2.
3.
I hope it.
3.
3.
Whether the
Regarding-
quantum of share in each of the legal heirs of late Bhagwan Das
Yes.
on the basis of the law.
Basically, I am agreed with the quantum of share.
Okay. You are all legal heirs of Bhagwan Das.
Yes, sir. My father is the son of Bhagwan Das and I am through Shivdal, we are the legal heirs. We are the grand
Of Bhagwan
of
Das.
Bhagwan Das.
Father is still there.
No, Lord. And
Father
first
has passed
appellate
away.
court lordship granted some share to the
Okay.
some dead person.
Third, Miss R. Chaudhary, learned counsel for the appellant, who has. Madam, why do you address the court in a second appeal?
But
Why do you address the court in a second appeal?
sometimes
What sometimes?
some court says lordship memorandum of appeal should
Yes,
be.
memorandum. Why do you address?
Sir.
Appeal is a continuation. Where is the form? You see the form. You should not address the court.
Some court lordship say that there should be addressed the.
To the Honorable Chief Justice. You don't write that.
Sir.
Unless it's an application
Sir.
accompanying the appeal, you definitely address. These are memo appeals. You try to
Normally, we write memorandum of appeal from appellate.
try to follow the prescribed procedure. This is the old practice. Don't.
Sir.
And somebody will see this, then they'll think that this is the procedure.
I'll take.
Okay. Petitioner who has preferred this second appeal against a judgment and decree dated 7/12/2023, passed by the learned civil judge, Senior Division Dhubri, in title appeal 28 of 2019, whereby there was part modification of the original judgment and decree dated 29/6/2019, passed by the learned Munsif number 2, Dhubri, in title suit number 325 of 1986, full stop. The appellants are the plaintiffs, and the suit was instituted for partition, full stop. This court has also been informed that initially the suit was decreed, which was however reversed by the first appellate court, and against the said reversal, the present appellants had earlier preferred RSA 64 of 2003, in which there was a remand order dated 22/5/2014, and the present judgment arises from such remand order. Full stop. Para. The appeal is admitted on the following substantial question of law, full stop, whether the findings arrived at by the first appellate court on the quantum of share of the appellants who are the legal heirs of late Bhagavan Das are on the basis of the materials on record and the relevant law holding the field. Para? Any other substantial, which may be framed at the time of hearing. Para? Let steps be taken for service of notice upon the respondents by usual process. Steps within 3 days. List after 6 weeks along with service report.
That I did.
I have for
stay.
stay of what?
Otherwise, but proceed.
Partition. It's your suit.
As per.
Unless you go for an execution, where is the case?
If the other party goes for execution, they are also entitled for
You press it whenever it's necessary.
at this in IA.
Tell us why. It is your suit.
Yes, but my suit.
What state you want?
Shares are already given to defendants also.
Was there a counterclaim?
No.
We'll consider at the appropriate time. Next.
Apply.
55, so please.
May I please?
Yes.
My lord, before proceeding submission method at page 47, draft method by translating the plaint method. Before proceeding method at page 47, while translating method the plaint method, some typographical error was
47.
at page 47. While translation going.
Okay, no problem.
My lord,
Yes, please.
my lord, my lord, I was the defendant, my lord, this time for loss was the defendant. The suit was filed for realization of 7,55,450, my lord.
I'll go to 20%. Petitioner, the appellant is the defendant.
My lord.
How many appellants?
My lord, so it's arising out of money suit.
Money suit.
Money. My lord, it was the money suit was filed for recovery of an amount of 7,55,450, my lord, due from the defendant.
Yes.
In which we have filed our WS, my lord. Thereafter, my lord, at
My lord, I take your lordship to first at page 60,
60.
60, my lord,
Yes.
in which we have submitted the draft list, my lord. At page 61, the issues I take to the original 61A. The
Yes.
issues were framed by the honorable court, my lord. Issues were framed by the honorable court, my lord, initially, and thereafter the issue number 3 was struck down by the honorable court by itself on 26/11/2020, my lord. By its order dated 26/11/2020, reflected at page number 62. The issue of the plaintiff while filing the money suit is to a hand note, my lord. In the hand note where it stated that I have taken a loan of total 7,55,450 on 3 subsequent dates. And the prima facie of the money suit depend upon that hand note, in which, my lord, the FSL was also contacted. The FSL officer has also come before the honorable court and has deposed before the honorable court, in which initially the honorable court has framed the issue number 1, 2, 3, and 4, out of which issue number 2 and 3 was, my lord, divided, in which the honorable court thereafter has struck down the issue number 3, which vitiated the whole proceeding of the money suit, my lord. My lord, I take your lordship to the
While buried in the case record for February.
I take your lordship for a second to page number 143, the vernacular at 143.
Now then the decree was
Yes.
passed on the basis of what?
On the basis of oral testimony, whereas, my lord, the whole issue of the plaintiff while filing the suit was on the basis of the hand note along with the oral testimony of the PW's. So, my lord, the honorable court while passing the judgment has stated, so the FSL report states that there was some, my lord, I take your lordship for a page number 144 for a second. 144.
144. 144, yes.
44. Yes, my lord. 143 is the type copy, 144 is the original for my lord.
144. Yes, 144. Suktipatra.
Yes, my lord. Suktipatra. My lord, here in this Suktipatra, my lord, is not, my lord. Here, my lord, was only with regard to one leg. My lord, to see the variation from the Aru, from the last part. It was from a different ink and different language, and it was quoted later on. So main dispute was with regard to one leg, and the remaining of the 3 lakh and the 3,55,450 was subsequently put on in the hand note. With regard to that, FSL was conducted. FSL came positive in our favor. Interestingly, the PW2, who was the husband of the plaintiff, has stated that, admitted that this part was written by him, my lord. Invariably, after all the depositions being submitted on the on record and after the conduct of the expert opinion also, my lord, the honorable court struck down the issue number 3, which was the prime issue. Striking of the issue number 3 vitiated the whole proceedings of the, and the honorable court shifted the burden upon the defendant to lead the evidence with regard to taking of the money, which I have stated as in the substantial question number.
Now, this particular order, was it the subject matter of challenge?
Yes, my lord. No, my lord. This striking of the issue. No, my lord. Striking of the issue was, but in the hearing we have done on that aspect. In the appeal it was filed, but this particular order was not put to striking of the.
Now that don't you think that that would be an independent cause of action?
Yes, it should be. But my lord,
the issue was struck off when? 26/11/2020.
26/11/2020, my lord.
And when was the judgment pronounced? Initial
Uh,
judgment,
19 to 2021.
then you did not take any steps to.
No, but that was not taken by the defense at that.
Now let us see what were the issues before the trial court as framed.
My lord, that is at page number, my lord, 61.
Page 61.
61. I thought may go to or 61A is the. Initially, the Honorable Court has framed it. And thereafter, the subsequently it was
No. Let us see the judgment.
judgment. My lord, 30, it starts from page 31.
31.
It starts from 30 with regard to issues, my lord, from 34. That's 34, paragraph number 4. Paragraph 5.
Okay, there is a reflection that it was
My
struck
lord.
off.
Yes, my lord.
Okay.
It has been stated that petitioner has sent that issue, but Honorable said that was not.
This is an independent cause of action. It was not struck off at the time of delivery of the or consideration of the judgment. It was struck off on 26/11/2020 and the judgment was delivered thereafter.
My lord.
It was definitely struck off with your knowledge.
My lord, that was within my knowledge.
And what was the grounds you had taken before the first appellate court?
My page 15 is the
15.
page 16 is
16.
my lord, it is the
Yes.
The Honorable Court has at page 21 has taken up one issue. The appellate court
21.
has stated that, my lord, the issue taken by the Honorable Appellate Court was whether the judgment and order dated 9/2/2021 passed by the Learned Civil Judge Junior Division in this is just and proper or needs any interference in this case. And the Learned Appellate Court also has at page 20 reflected with regard to profit as being the case of the appeal petition.
But that hand note was it taken into consideration? Was it exhibited?
Yes, my lord. It was exhibited, and on that basis, FSL was also done, and the officer has also deposed, my lord. The my lord, it is evidence of BW 121.
Page?
Page 121. My lord, forensic examination report, page 140.
140.
140. Here we enclosure 13, 140. The query was whether from line number 1 of the written hand note to line number 11 and from the line number 11 to line number 19 were written in two different points of time, that is, are two periods and duration. And with regard to pilot has stated, and the report is also an estimate.
Let us see your written statement.
My lord. Page 56, my
56. Okay. Yes, what are your substantial questions?
My lord, at page 14. 14, the relevance is 2, 3, and 4.
Heard Miss H.G. Barua, learned counsel for the appellant, who has preferred the second appeal against a judgment and decree dated 19/1/2024 and 9/1/2024 and 19/1/2024 respectively, passed by the learned civil judge, senior division, Lakhimpur, in money appeal number 1 of 2021, full stop, by the aforesaid judgment, comma, the initial judgment dated 9/2/2021 and decree dated 19/2/2021, passed by the learned civil judge, junior division number 1, Lakhimpur, in money suit number 6 of 2021, has been affirmed. Full stop. The appellant is the defendant in the suit. Full stop. Para. It is contended that in the written statement, comma, a specific plea was raised on the genuineness of the sole document which was the basis of the suit and was also exhibited as Exhibit 1, full stop. Reference has also been made to the evidence of the officer from the FSL in this regard, and also certain admission by the plaintiff witness number 2 on the said Exhibit 1. Full stop. Para. The appeal is admitted on the following substantial questions of law. Exhibit A, is it the FSL report
My lord,
or is it the hand note?
Exhibit A is the FSL report.
And hand note
Exhibit 1.
1. Whether the first appellate court, in affirming the judgment of the trial court, in considering the hand note within bracket Exhibit 1 to be a basis of the relief granted, is in accordance with law in view of the FSL report Exhibit A, as well as the evidence of the official witness. Full stop. Number 2, whether in view of the anomaly in respect of the Exhibit 1, comma, the decree could have been granted in favor of the plaintiff. Full stop. This court may frame any other substantial questions of law at the time of hearing with notice to the respective parties. Let steps be taken for service of notice upon the sole respondent by usual process. Steps within 3 days. List after 6 weeks for service report.
There is an IAM, because the money appeal, my lord.
Execution has they started?
No, my, not.
You press when they start execution.
Okay.
Yes, what is this?
Up to the last occasion. So Lordship peruses the last order, 2011-18. On that day, I have submitted a judgment of the Supreme Court, wherein Supreme Court in 2017-4 petition the file FP that
Yes.
market. 2017-4 SSC 150. There are directions given to all the courts as to how the transfer petition has to be dealt.
Yes.
Para 14, if your Lordship can be please take. 14 is the operating part, 14, 15, and 18 is the direction. I may read it slowly. We therefore direct that in matrimonial or custody matters, or in proceedings between parties to a marriage, or arising out of disputes between parties to a marriage, wherever the defendants respondents are located outside the jurisdiction of the court where proceedings are instituted may examine whether it is in the interest of justice to incorporate any safeguards for ensuring the summoning of defendant respondent does not result in denial of justice. Order incorporating such safeguards may be sent along with the summons. The safeguards can be number 1, availability of video conferencing facility, availability of legal aid service, deposit of cost for travel, lodging and boarding in terms of Order 25, and number 4, email address, phone number, if any, at which litigant from outstation may communicate. But this matter pertains to transfer of this petition, which I have filed, the husband has filed, before the principal civil judge, court number 1, which has been stayed after filing of the transfer petition by the wife. My humble prayer is that as per this direction of this court, Supreme Court, this can be dealt with by the husband can appear through video conference from the same court. The lady can appear in the court where she stays, nearest to the court where she stays. Her prayer in the petition.
Who is for the petitioner?
Last order was very specific. His submission was that
Are they aware that this matter would be upgraded or stay matters?
Okay, that can be.
I think that is the problem. I think we saw Miss Devi.
No, also that is not the. I have checked the Wakalat number. I have some different day.
Okay. Let us
But I
not
also
pass any orders at this stage. Let the matter reach on its turn. Or if in the meantime you get hold of any of the counsel.
I've tried to.
M. Khan is there. M. Khan. M. Khan is regular in the court. You try to contact M. Khan. Okay. We'll consider. AC to the book. Yeah, go to the book. Yes, Mr. Jha, what is this?
May I please, Your Lordship?
Yes.
Lordship is in this case, Your Lordship, my 2 PWs, the first examination which was closed. So I filed an application under 151 before the trial court, and that application was also rejected. Thereafter,
Your right to cross-examination of 2 of the witnesses of the
my evidence.
Your evidence.
My evidence.
You are the plaintiff.
I am the counterclaimant defendant. DW.
Oh, your DW.
Yes.
It was closed.
It was closed. Cross-examination closed. Ultimately, my evidence expunged.
Oh, your witness did not appear for
cross-examination.
So therefore, their evidence have been expunged. Now they are going to appear.
Now, Your Lordship.
Who is for the other side?
PC Talukdar, Your Lord.
Yes, yes. Try to get him. You'll have to pay some cost.
Your Lordship,
Pending suit of which year?
writ of your 2008, Your Lordship.
My God.
It is a fag end of trial, Your Lordship. It is date of
Fag end.
Your Lordship.
From 2008, 2024 is fag end.
Your Lordship, it is
There'll be fagger end, faggest end. We'll go to 2030.
Your Lordship.
You try to have Mr. Aludar will try to.
Your
will-
Lordship, one thing may be done, Your Lordship. A date may be given, Your Lordship.
No, try to have him. We don't like to
He
dispose.
he may be in that trial court, Your Lordship, in the civil court.
At 2 o'clock, have your chance.
Yes,
If
Your
he's
Lordship.
there, otherwise we'll accommodate you.
Your Lordship.
Okay.
Your Lordship.
These matters we should not keep pending.
Your Lordship.
Yes, Mr. Dutta, what is this?
Yes, Lordship. So one suit was filed by the plaintiff.
You are who?
I am for the defendant, auction purchaser. Suit is barred under section 34 of the Surfacey Act.
You are the defendant.
I am the defendant. I am the auction purchaser.
Defendant. And auction defendant is auction
Respondent
purchaser.
number 1, 2 are the plaintiff. And 3 to 5 are representatives of the
Auction
bank.
purchaser.
Yes. And the
In a surfacey proceeding.
in the service in the service.
Oh, then
During the after I had purchased the property, they moved before the High Court, this honorable court, division bench, challenging the auction purchase.
The petition, the plaintiff.
The plaintiff.
Plaintiff initially filed
At read petition number 6015 of 2014.
Right, WPC
15 of 2014.
Yes. For against the auction purchase.
Yes, the playing for against the auction purchase. And the redemption of the mortgage.
Yes.
Then the Honorable High Court initially by an at motion stay the proceeding.
Auction.
The auction was already been done.
Further proceedings.
Further proceeding. Not to dispose etc. Then thereafter, the Honorable High Court has disposed that writ application by directing the plaintiff to approach the DRT.
Okay.
On the basis of a judgment of the Honorable Supreme Court.
Yes.
Yes.
Said to be
done. Then, within the stipulated time as framed by the Honorable High Court, they did not approach. Later on, they came before the again division bench with an interim application, praying for extension of time again. At that time, Honorable High Court has rejected their application by holding that their act is fraudulent, also not bona fide, because by an observation that during the proceeding, they have sold out a part of the mortgage property, and also hold that also they did not deposit any amount, even if called by the court. So with that observation, their application was disposed of. Neither they approached the DRT, and the Honorable High Court has closed the matter. Then after the final order of this Honorable Court, then within 1 month, they have filed a civil suit before the Civil Judge Senior Division at Dibrugarh by concealing the last order of the Honorable High Court. By concealment of last order, wherein they were, their application was rejected. On appearance, we have filed an application under section 34, saying that the civil suit is not met. And in view of the order of this Honorable High Court. Lordship may have a kindly look of the High Court order first.
No, you filed under what section?
Order 7, Rule 11.
711. That 34 is a bar.
Bar.
Under the DRT.
Yes.
The civil court has no
The
jurisdiction.
civil court, and the civil judge says that no, there is some points for adjudication. So therefore, our application was rejected. Against that, we are before this one.
You filed 711.
711. That was rejected by the impugned
You
order.
took the plea of bar of say 34.
34.
Rejected.
That was rejected.
Is there by any chance, is there plaint saved by some observations made in Mardia Chemicals?
That we have all placed, because Mardia Chemicals is very clear that unless there is a fraudulent act,
Fraudulent, yes.
yes, or the claim is so absurd.
No. Are they taking advantage, or is their case is based on certain pleadings that fraudulent activities were there?
They are only pleadings, Your Lordship, in the para 26 of the plaint. They're saying that by obtaining a loan from the same bank, we had purchased.
Okay.
The civil code taking that paragraph 26 as if that we have mortgaged that suit property, that the auction property, and we got a loan. But that loan, as per the bank written statement also, that is a different loan, mortgaging my mother's property.
Your auction purchaser, that's a different loan you had obtained.
Yes. There's a Tingshukia branch. We have obtained a loan by mortgaging my mother's property. This is a separate loan.
And this property?
This property is different. I paid the entire money and purchased.
Yes, how do you overcome 34? Who is appearing? Mr. Padgiri for?
1 and 2, my lord.
Who are you?
Plaintiff.
Plaintiff.
My lord. And my lord, the respondent bank has not appeared today.
Who's for the bank?
Central bank, my lord.
You're for?
All,
Okay.
my lord, all 1.
Has the bank appeared otherwise?
Yes.
Yes,
Who's
otherwise,
there?
Mr. Sharma Pare.
Oh, Mr. M. Sharma.
M. Sharma.
Get him at 2 o'clock. We'll try to dispose this of. Yes, what do you say, Professor? What do you?
My lord, that I filed the title suit, my lord, regarding the fraudulent action of the, my lord, respondent bank.
Let us see your plaint.
10, my lord.
Page 23. Page 20.
What are the relief you are seeking?
My lord.
Now, you will find at page 36 there. Same prayer which they have sought for before the High Court.
For declaration that auction sale made by the defendant number 1 to 3 in favor of the defendant number 4 on 27/9/2014 is legal, invalid, null and void, and liable to be declared cancelled. Second, for declaration that the right, title, interest, and possession of the
You know the law. You don't approach the DRT under 17. Satyavati Tondon has been again explained in a way, and not only explained, guidelines have been laid and to be circulated among the different registries.
during the pendency of the writ petition, I approached before the bank authority.
17, did you file application under 17?
Is the undervalued, my lord.
No. Did you file 17 application?
No.
Why not? You have a remedy in law. It has been reiterated time and again.
In spite of the direction of by this honorable court.
There have been number of cases, and recent case last month, very strict observation has been made. In spite of the clear direction in Satyavati Tondon, you have it's not being followed.
But,
if you want, we can we'll have it at 2
the
o'clock.
bank authority has not disclosed, my lord, who purchased the, my lord, property, my lord.
You have a remedy in law. This you cannot approach the. How do you overcome 34? The entire meaning of this special enactment will be defeated. Obviously, in case where you can demonstrate that there has been fraudulent activity, which is very difficult, and there may be certain officers who are malafide, but malafide exercise of powers and fraudulent activity are different. You show your cause in 17, and why haven't you disclosed the second order of the division bench or learned division bench? You have not disclosed.
No.
Your
3rd of September.
Your application for extension was dismissed.
Dismissed, my lord.
3rd September
You
2018.
disclose everything, get an order. Your conduct is not above board. Try to have Mr. Sharma. Others also will. Could you locate the Learned Counsel for the
Yes.
bank?
Yes,
Bank.
you are right.
Bank.
Coming, Lord.
Case in court number 13.
Mr. Sharma.
Yes, sir.
Legally. Yes.
May I request, Honor, she will find plaint at page 23. And in fact, the plaintiff,
DRT Act. Recovery of deaths. Surface economy. Separation. Yes.
yes, consequently, I will look at plaint. In plaint, the plaintiff himself said that he has committed fraud by selling out the mortgage property. Page 23, Lord, she will find para 7. Para 7 and para 25.
23.
23.
Para
7.
7.
Yes.
Please read.
That in course of business of Ma Shakti Rai Smith, against whom the loan was taken, the plaintiff number 1 was suffering from such and such different side, as well as to a creditor, sold out the land, an asset of Ma Shakti Rice Mill in a consideration of rupees 75 lakh to such and such. Sale deed executed by an amount rupees such and such 25 has been by her paid through check by her husband against the sale consideration, which got dishonored due to insufficient of fund, and for that entire loan could not be liquidated.
They sold mortgage property.
Yes. He himself said that he sold out the mortgage property to liquidate the loan, but that was not affected due to the dishonor of part payment. He himself said.
No, we may not go into those aspects also.
Yes. Now, para 26, which the learned lower court, case 7,
page,
para 26, page 32.
Part of the impugned order.
No, the plaint.
Let us come to the impugned order.
Yes. Impugned order, lot you will find at page 56, operative part, page 68. 68 below.
It starts at?
Start at page 56.
57.
56, but you will find the operator for page 68. 68.
Order 1811.
Yes. 1811-20.
Your 711 has been rejected.
Yes. Yes.
Yes. Operative at page 60?
Page 68.
68.
Down below. Look. That being so, perusal of plaint and specifically paragraph number such and such of the state plaint reflects about the prima facie existence of collusion in respect to the manner and procedure of disbursement of loan by the defendant bank in favor of the defendant number 4. That is the auction purchaser, as well as the manner in which the auction sale was conducted by the defendant bank, as a result of which the entire dispute as alleged is needed to be adjudicated in merit. And the same is only possible to be determined by appreciation of the evidence which is being adduced by both the side during the trial. Insofar as the Ellis implied bar of jurisdiction of this court, owing to outcome of the writ petitions reflected in the foregoing paragraphs of this order is concerned, the same is not squarely applicable to this case, keeping a note of the fact that the absence of knowledge of the plaintiff with respect to the completion of the auction sale and awarding of sale certificate in favor of the defendant number 4, which is stated to be come to their knowledge at a later point of time, which could not have been agitated by the plaintiff during the course of hearing of the writ petition. It is absolutely false, absolutely misappropriation of the fact. Because in the writ petition, they have challenged the auction sale in the writ petition, which is reflected in the first order, in spite of their best possible effort. Being so, taking a note of the development that has been taking place with respect to the Ellis collusion, thereby leading to the fraud on the part of the defendants during and after the course of hearing of the writ petition, the instant suit appears to be prima facie maintained.
Yes.
Now, Lordship, kindly have a look at page 45, the first order of the Honorable High Court.
45.
Page 45, order dated 24th of 11/2014.
By which they were directed to
No,
approach.
this is the first order. The High Court was pleased to look at the status.
That we are not.
Now, why I am saying so, Your Lordship, that page 46, Lordship will find that they have challenged the auction purchase, auction sale process.
Yes.
That therefore,
Where,
now, it is the page 46, second paragraph, third paragraph. The case of the petitioner is that the will send mortgage loan such and such on the balance got such and such. According to the petitioner, in spite of above prime land mortgage against the state loan, account was sold by public auction. Sold by public auction at a price of 29.5 lakhs. So therefore, Lordship will find that they have challenged the auction sale in the writ application. Now the second order, whereby they are relegated to the DRTA, that is at page 48. Order dated 21/5/2018. Last line, on the page 49, we therefore, having regard to the decision of the Supreme Court is Sattavati tendon, direct the petitioner to avail remedy under section 17 such and such. At this stage, Landed Council for the petitioner has prayed that interim protection granted earlier by this court to the petitioner allowed to continue to some reasonable period. To this prayer, the Landed Senior Counsel for the bank has fairly agreed. We accordingly direct the parties shall maintain status quo as exists today with regard to the loan transaction in question for a period of 2 months.
Okay.
Now, thereafter, the third order passed by this the division bench, Honorable Division Bench, that is dated 3rd of September 2018, which they have counseled before the Landed Civil Court. Page 50, page 51. Last page 51, the last paragraph. Despite liberty given, the applicant did not avail the remedy under section 17 of the Surfacey Act within the period stipulated by this court. Rather, the applicant made application before the Debt Recovery Tribunal Guwahati seeking condonation of delays as section 17 appeal could not be preferred within the aforesaid 1 month period. The said application, however, was dismissed by the tribunal by the order dated such and such. In this situation, the present application has been filed. We find no merit in the present application primarily on 2 counts. Firstly, the applicant was not diligent enough to avail remedy under section 17 of the Surfacey Act, despite sufficient time granted by this court to avail the remedy by the order passed in such and such. Secondly, it is brought to our notice that the applicant have suppressed material fact inasmuch as part of the mortgage property was sold off by deed number such and such dated 23/11/2015. The bona fide of the applicant to pay back the outstanding loan amount is in question. Even before this court, the applicant is not willing to pay 50% of the outstanding amount. His conduct does not merit grant of relief in the present application. Accordingly, the same stand dismissed. Then thereafter, this
Mr. Datta, in fact, he had indeed approached the tribunal, but it was beyond the period of
limited.
No, beyond the period of time
Granted
prescribed
by
by
the
this
court.
court.
Yes.
And therefore, since his application was rejected on that count, he had filed this IA that you give me extension.
Yes.
And division bench said that no, we are not going to.
That was rejected.
Okay.
And thereafter, within a month, they have filed a suit. And this order particularly, they have considered. So for para 26 is concerned.
What is the relief sought in the suit?
The relief is to set aside the auction sale. How it could be allotted by the civil court? Because the sale certificate already issued by the bank to in our favor. Therefore, as per the enforcement rules 2022, I have a vested right over the property. As per rule 9(6).
Okay.
May I please, this chemicals limited case, Madhya, paragraph 50 and 51, this is very specific. That if the secured creditor is alleged to be fraudulent and or claim is absurd, then only the civil code have it.
Please give the citation of Madhya.
Yes, paragraph 50 and 51.
Citation?
2004, 4 SCC P11.
Para 50?
50 and 51. 51 is relevant. 50 is saying section 34. 51 says page 349.
Yes.
However, to a very limited extent, jurisdiction of the civil court can also be invoked where, for example, the action of the secured creditor is alleged to be fraudulent, or his claim may be absurd and untenable, which may not require any proof whatsoever to say precisely to the extent the scope is certain. This is not the case of the plaintiff. He said the fraudulent. Why? Because the reserve price, which is it is sale below the reserve price. It is all determinable by the TH. And when the entire action is over, how it can be reverted back, my lord?
Okay, yes.
Then two judgment our High Court, may I please you?
Regarding?
One is 2016.
Regarding?
Regarding section 36. The civil code but jurisdiction. Two judgment. One is 2016. 6 JLR para 10.
Just a minute, please.
Lord. Ten and 11.
Ten and 11.
Lordship. 2016, 6 JLR, page 5.
Anything where it has been explained or what? In 2006-16, there is nothing.
Nothing. There's a
No.
general,
No,
general,
general, but
yes.
any proposition where.
Yeah. Another judgment, 2022 one GLT 257, which is also cited as a monoputra.
2022.
There's a recent judgment by
2022, 1 GLR, 1
GLT 257. It's Monu Guwahati 0750 2020.
ICICI.
Paragraph 10 and 14.
10 and
14. Wherein the other judgment also discussed by this honorable court. It is no longer res intriga that when a case involves fraud, the bar under the Act 2002 does not apply. But the question involved is in respect of the instant proceeding as to whether.
You are reading which paragraph?
Paragraph 10
10.
of ICICI Bank.
Yes. 10 starts with what? Applying the law.
Yes. Paragraph 10.
Applying the law.
Yes. No.
It's a different paragraph then. How does it start?
It is no longer res intriga.
Just a minute, please. Paragraphs differ in Manupatra.
Yes, Manupatra is different. Manupatra दिए तो check करके दिए Manupatra import से ये है ना we have placed Manupatra citation.
In that 11, paragraph 10 starts with something else.
In Manupatra,
applying the law laid down by this court in the aforesaid decision.
it's 15.
Oh, this
This
is
Manupatra.
Okay. It's
Yeah.
10, but why come? It's 10, you're correct.
Yes,
But there are
my lord.
9, 10.
In that case, your lordship, that the father says, who are the guarantor, said that I did not put my signature.
Just a minute.
That was the allegation he has filed as well.
Yes, please. It is no longer.
It is no longer res intriga that when a case involves fraud, the bar under Act 2002 does not apply. But the question involved is in the respect of the instant proceeding as to whether the allegation of fraud made is just an eyewash on account of clever doctrine or can be termed as an allegation of fraud within the meaning of Order 6 Rule 4 of CPC. I just take a pause here. That the fraud they have released in the plaint is nothing to say to be a fraud. The fraud is to be said by committed by a bank, which is to a very high extent. He said that in the plaint that I took a loan from the said bank by mortgaging the said property, which is not correct. Because that admittedly that mortgage property is something else. And so far the reserve price is concerned, they have made an allegation that the mortgage property was sold below the reserve price. And it is admitted in the plain lordship that he has the knowledge of the notice published in the paper of the auction sale. He did not approach to the bank and clear the dues. Not a single farthing he has paid. If he has paid, your lordship, that any amount, any short of amount of the loan amount, and then say that yes, I am a lawful owner. I would like to redeem the mortgage and I would like to make the payment. Please accept my 50% payment. Even the High Court says that the High Court has asked the applicant, the plaintiff, to pay 50% of the amount of the loan amount, which he refused to make any payment. So bona fide on the part of the plaintiff, that is absolutely highly questionable. So the equity does not demand any relief to the plaintiff. That's my humble perspective.
May I reference to fraud without any substantial materials will not debar a court from exercising powers under 711.
Yeah, absolutely. Absolutely.
I think the expression used, clever drafting, is also used in Aravindam case.
Yes, yes,
By
correct, correct.
Justice Krishna Iyer.
Yes, correctly.
72 or something.
Yes, yes.
What was the citation? Aravindanam.
Exactly.
There was a case Aravindanam. Yes, here. Paragraph 31.
Paragraph
31.
You can hear. Devastate.
77. This was 77. Please read paragraph 31 of that judgment of our High Court.
Yes, yes. Paragraph 17.
In the case of T. Aravindanam.
Yes, paragraph 31.
Yes.
Paragraph 5 of that judgment. We have
Yes.
not the slightest hesitation in condemning the petitioner for the gross abuse the process of the court, repeatedly and
Unrepentantly
resorted to. From the statement of the fact found in the judgment of the High Court, it is perfectly plain that the suit now pending before the First Municipal Court, Bangalore, is flagrant misuse of the mercies of the law in receiving plaint. The learned municip must remember that even a meaningful, not formal reading of the plaint, it is manifestly vexatious and meritless in the sense of not disclosing a clear right to sue. He should exercise his power under Order 7, Rule 11 CPC, taking care to see the ground mentioned therein is fulfilled. And if clever drafting has created the illusion of a cause of action, yes, nip it at the bud the first hearing by examining the party searching under the Order 10 CPC. An activist judge is the answer to irresponsible lawsuits. Absolutely, very, very lucid language. As Justice always. Is it 2018 suit, Your Lordship? Is still continuing.
Okay. Yes, that's all?
Yes.
So kindly see, my lord, paragraph 17.
Of
the, my lord, petition, my lord. Page 17, my lord. Page 17.
Okay.
Plain. Paragraph 12. The petitioner himself admitted that, my lord, the bank authority, my lord, some minor lapses on the part of the bank. Impugn order failed to consider that there may be some minor lapses on the part of the respondent while auctioning the mortgage property. And such aspect has to be.
There may be some. He's assuming that even if there is minor lapses, it can be looked into by the DRT under 17.
In case of fraud, the civil court only,
What is the fraud? Let us see how have you alleged fraud. I'm only saying fraud will not do. There has been undervaluation of the property. That is the only thing.
Purchased the property, my lord, from the state bank, my lord, obtaining the loan, my lord.
That's a different loan, different property. That is not even your case.
And my
You
lord,
said that the property was undervalued. Those will be looked into. Your right to seek justice has not been curtailed. It is still open. It was open. 17 rejected because of your lack of diligence. You have 18.
But and second thing, my lord, is tell below, my lord, also, my lord, below the, my lord.
Those can be raised, but those to allege frauds, fraud is something which is vitiate everything, no doubt. But only saying fraud will not do. Mr. Sharma. No, he is trying to take care, or rather, we are also concerned that whether the relief sought would come within the exception, very few exceptions in the case of Mardia chemicals. That is the only issue which for fraud. He has said fraud, but will that be enough?
That we have placed.
How, where, in what manner it has happened. This is what the particulars of the dates as to when the fraud has been happened. That's what the valuation of the
See, 7-Eleven adjudication is not not based on the stand of the defendant. The defense of 7-Eleven has to be adjudicated from what appears from the plaint.
Yes.
Appears from the plaint. If it appears that it is barred by law, subsection D, then he should exercise powers, because no point wasting time of the court. Now, the allegation is that you have a bar under 34. So it's barred by law. 34 has been discussed and explained in Mardia Chemicals to that extent that even though civil court jurisdiction is barred under 34, under certain circumstances, wherein maybe one of the circumstances is a fraud, then it still be open for a civil court, because tribunal may not be in a position to decide whether fraudulent activities are there or not. Only for saving those kind of cases, will his case or will his allegation come within those ambit, within that ambit? No, the fraud he is alleging is on the price also fixed by you. That the reserve price is much below than the market price.
on the basis of the valuation fix the reserve price. If by any of the actions taken under the surfacey, the guarantee is the only appropriate approach. And the action which has been challenged under the plaint is only the surfacey action. Is none other than. And in one of the courts, it says that any other, let's say, compensatory suit, it can be maintained. There is no bar. But not the surfacey action.
The damage suits or compensatory is on for different activities. That ultimately by the action you had suffered some loss, but it is not to challenge any action of the DRT. That's
Action cannot.
by a secret creditor.
And it also say fixing of the price is one of the parts of the good line of
Okay.
In a recent judgment, you know, recent judgment, three judges bench of our Honorable Supreme Court. Here, therein, the auction purchaser has paid the money. Then the borrower came and he said that I will make a more payment. Then in the High Court, where the proceeding has been carrying out, then the bank has agreed and take up the money. The Supreme Court said once you take the money from the auction purchaser, you cannot revert back because the auction purchaser has.
You are referring to PHR?
No, it says Taylor LP versus Vapna Motors, 2024.
Date?
It's date 2024 2 SCC.
No, date.
Date of the judgment is September 21, 23. I have a judgment.
We have a judgment of 10th of April. 2024.
Okay. Lordship is always ahead.
No, you should be ahead of us.
Yes.
You should be ahead of us.
Yes.
We will not do research.
No,
We will
I'm
research.
only referring because my vested right under the enforcement.
But this is not in the directly in the context of 34 bar. But this can be, we will also take the aid of this because when there is a clear bar under 34.
Yes.
And that has clarified that 226 may not be an absolute bar. But here even the jurisdiction of 226.
Yes.
The reiteration of Satyavati Tandon has been
reiterated.
Yes, towards the last part.
Yes. 30. It has however been clarified that the High Court will not entertain a petition under 26 contesting even effective alternative remedies available to the aggrieved person or the statute under which the action complained or has been taken itself contain a mechanism for redressal of grievance. Undisputedly, the present case would not come under any of the exceptions as carved out by this court in the case of Sevilal. We are therefore of the considered view that the High Court has grossly erred in entertaining and allowing the petition under Article 226 Constitution. While dismissing the writ petition, we will have to remind the High Court of the following words of this court in the Satyavati Tandon. Since we have come across various matters wherein the High Courts have been entertaining petition arising of the DRT Act and the Surfacey Act in spite of availability and effective alternatives. Correct?
But it is not Satyavati Tandon. It's Satyavati Tandon.
Tandon. Yes, Tandon. Sorry. Tandon. Actually, we used to the surname of Tandon.
From
the
whom?
Tandon. Satyavati Tandon.
From whom have you, who do you know as Tandon, surname? Tandon? Anyone?
Robina Tandon. Decca reminded me.
We were expecting a quicker answer.
Yes.
Okay.
Thank you.
Regarding my contention, my lord, I have said that on
Please.
basis of that, my lord,
Yes.
the Learned Trial Court, my lord, called the order. One, my lord, 2021 9 Supreme Court SCC
2021
9 SCC
9 SCC.
Page number 99.
Name?
Name, my lord, Sri Hori Hanuman Das Kotala versus Hemant Vishal Kamar and other.
Paragraph?
Paragraph, my lord, 70.
17.
17.
What has been stated?
21 9 99. Page number, my lord, 107.
Paragraph 17.
7.
Yes.
Order 7, Rule 11D CPC provides that the plaint shall be rejected where the suit appears from the statement in the plaint to be barred by any law. And in order to decide whether the suit is barred by any law, it is the statement in the plaint which will have to be considered. The court, while deciding such an application, must have due regard only to the statement in the plaint. Whether the suit is barred by any law must be determined from the statement in the plaint, and it is not open to decide the issue on the basis of any other material, including written statement in the case. The petition of the respondent, my lord, on his plaint categorically stated that the fraud taken by the bank. That's why, my lord, I approached before the civil court. And, my lord,
Where is the admission? Categorical admission.
regarding, my lord, regarding valuation part and regarding,
That is not
my
an
lord,
admission. It is not an admission. There is absolutely no dispute on what the proposition as law laid down. In fact, that was what we had suggested, that even filing without any defense statement, From the plaint itself, it should appear that there is a bar in law. Under say, subsection D, there has to be a bar in law. Here in this case, res judicata was the bar. So it was not, under res judicata is pleaded in the statement of defense, it cannot be adjudicated. From the plaint, it may not be able to be discerned whether there is a res judicata bar. So it came only when the written statement was filed. So maybe they thought that it may be an issue to be decided, but not 711. So under those circumstances.
Second, my lord, 2016 4 GLT 633. Giridhar Saha.
2016
4 GLT.
(633). Para?
Para my lord 23.
Yes. 23. Please read.
Hello. From the aforesaid observation made by the apex, Honorable Apex Court as well as the division bench of this court, it is thus apparent that a civil suit challenging any of the measures initiated by the secured creditor under section 13(4) of the surfacey may be maintainable only if a clear case is made out falling within the ambit of the exceptions carved out in paragraph 51 of the Mardia Chemical. If the plaintiff discloses full material fact and particulars of fraud depicting on the face of the record that measures initiated by the secured creditor was being exerted by deliberate deception with a design for taking an unfair advantage upon the borrower, raising an issue that goes into the root of the matter, and if it can be readily inferred that the tribunal under section 17 of the surfacey would not have the jurisdiction to grant the relief set forth in the suit, a civil suit would be maintained. On that basis, my lord, to judgment and the other judgment also, my lord, the Honorable Learned Trial Court passed the order rejecting the, my lord, petition of the, my lord, petitioner.
How do you explain your conduct so far as your approach to this court is concerned in the earlier proceeding?
Proceeding, my lord,
Have you disclosed in the plaint that you had filed 17, it was rejected? Have you disclosed? Is there a disclosure?
No, 3/9/2014 order was not disclosed.
No, in the
Writ
suit.
petition was disclosed.
No, in the suit, in the plaint.
Yes.
Has it
Filing
been
of writ application was disclosed.
No, not on disclosure. In the plaint, has it been disclosed that he had earlier filed 17, which was rejected?
No, that order 3/9/2018.
What is
3/9/2018
No,
order.
that is the division bench.
Division bench.
We are not on the division bench. We have seen that the extension was sought for because his approach to the DRT was negated because he did not come within the prescribed period of time.
He has referred there that he has filed a section 17 application.
Then?
Which was rejected, being time bound.
Okay. Thereafter division bench not.
Thereafter the division bench, that order was done.
Okay. Okay.
Wherein the High Court has questioned his.
Yes, Mr. Padgiri, anything more?
My lord, I have approached before the DRT, my lord, under 70 with a condonation, my lord, but without merit, my lord, rejected the petition of the, my lord.
No, that aspect has been taken care in the subsequent
I have
decision of the division bench in your IA 3157 of 18.
My lord.
In the order of 3/9/2018, division bench has deprecated your conduct. You were given a particular time to approach the DRT.
my lord.
You did not approach. You approached after that time. You did not deposit any money in the court. And rightly, the DRT had dismissed your petition. And her division bench has said it is dismissed. We cannot now extend. And when did you institute the suit?
Suit, my lord,
12/10/2018.
12/10/2018. You should have at least disclosed the DB order of 3/9/2018. And your, Mr. Padgiri, your rights under Section 18 is still available. It's a different matter if it's got barred by time limitation. You can file appropriate application for condonation, seeking that you had been seeking your remedies in a wrong forum, maybe a forum without jurisdiction. You might get the benefit of 14. Okay. The instant application has been filed under Article 227 of the Constitution of India against an order dated 18/11/2023 passed by the learned civil judge, bracket senior division, bracket close, Dibrugarh, in Meet J case number 279 of 2023, arising out of title suit number 108 of 2018, full stop. By the aforesaid order, comma, the application filed by the present petitioner as defendant under Order 7, Rule 11, within bracket small d, read with Section 151 of the CPC for rejection of the plaint has been dismissed. Full stop. Para. The facts which emerges from the petition and the documents annexed is that the petitioner is an auction purchaser in a proceeding before the learned DRT. Guwahati. Guwahati. Full stop. The said auction purchase was the subject matter of challenge in a writ petition filed by the respondent number 1 and 2, which was registered as WPC 6015 of 2014. Full stop. Though wide an initial order dated 24/11/2014.
Only one.
Respondent number 1, huh? Number 1 and 2.
Yeah. Now respondent number 1 was died. It was substituted by legal heir. The predecessor interest of respondent.
Oh. Then 1 and 2 actually. 1 and 2, who are the successors of the
Of Purvat Rajkumar.
Of the no, by the predecessors and interest of the respondent numbers 1 and 2. Full stop. Though wide an initial order dated 24/11/2014, comma, there was an interim stay, comma, wide the final order dated 21/5/2018, comma, the writ petition was disposed of, directing the said respondent to approach the DRT under Section 17 of the Surfacey Act, of the so-and-so Act, within bracket Surfacey, 2002, Full stop. It, however, transpires that the approach to the DRT was not done within the time prescribed, and accordingly, when the application was filed beyond such time, comma, the same was rejected. Full stop. The said respondent had thereafter filed IA Civil 3157 of 2018, praying for extension of time. Full stop. The Honorable Division Bench, however, by order dated 3/9/2018, had dismissed the application in which the conduct of the said respondent was also deprecated, and the issue of lack of bona fide was also discussed. Full stop. Thereafter, comma, the present respondent number 1 had filed civil suit, the above civil suit, on 12/10/2018. Full stop. In the said suit, registered as title suit number 108 of 2018, comma, the present petitioner as defendant had filed a petition under Order 7, Rule 11 within bracket D, read with Section 151 of the CPC, which was registered as Ms. J case number 279 of 2023. Full stop. In the said petition, comma, a specific plea of bar of civil suit under Section 34 of the Surfacey Act was taken. Full stop. However, comma, wide the impugned order dated 18/11/2023, comma, the aforesaid application has been rejected. Full stop. It is the legality and validity of the said order which is being questioned in the present proceeding. Full stop. Para. I have heard Sri B. Datta, Learned Senior Counsel, assisted by Sri S. Deka, for the petitioner. Full stop. I have also heard Sri K.R. Padgiri, Learned Counsel, for the respondent number 1 and 2. Respondent numbers 1A, 1B, 1C, and 2. Whereas the respondent number 3, Central Bank of India, is represented by Sri M. Sharma, Learned Counsel. Full stop. Para. The Sri Dr. the Learned Senior Counsel has submitted that the entire conduct of the plaintiffs in instituting this suit is and lacks bona fide. Full stop. Apart from the bar of Section 34 of the Surfacey Act, comma, there is no complete and full disclosure and candid disclosure of the facts involved. Full stop. It is categorically submitted that the final order, that the order of the division bench of this court dated 3/9/2018, passed in IA Civil 3157 of 2018, was intentionally suppressed. Full stop. It is submitted that under Section 34 of the Surfacey Act, comma, there is a clear bar of the civil court to entertain any suit or proceeding in respect of any matters connected to the Act of 2002, full stop. It is further submitted that the plaintiffs were not remedialess as they had an adequate and efficacious remedy under Section 17. And in fact, the said remedy was directed to be availed by this court in the order dated 21/5/2018, which was not done by the plaintiffs within the time prescribed. Full stop. Reference has also been made to the order dated 3/9/2018 of the Honorable Division Bench, wherein the conduct of the plaintiffs, respondent plaintiffs, have been deprecated, both with regard to the lack of bona fide and also the both with regard to lack of bona fide and the lack of due diligence. Full stop. Para. The learned counsel has submitted that though the Honorable Supreme Court, in the case of Mardia Chemicals reported in so-and-so, has laid down, has carved out certain exceptions in construing the bar under Section 34, such exceptions are to be given a restrictive meaning, and only in case of apparent fraud, a suit may be held to be maintainable. Full stop. It is submitted that in the instant case, except a bold statement, BALD, bold statement made in paragraph 7, that the property was sold below the reserve price, there is no pleadings regarding any fraud. Full stop. Para. In support of his submission, the senior counsel for the petitioner has relied upon the following cases. Number 1, 2016 4 GLR, page 5. Number 2, 2022 1 GLT, page 257. Full stop. Para. In the case of Vijaya Bank Supra, this court has held that in view of Section 34 of the Surfacey Act, the jurisdiction of civil courts are barred for entertaining any suit or proceeding arising out of the Act. Full stop. In the case of ICICI Bank Supra, this court, after discussing the relevant laws on the aspect of on the present aspect, has laid down as follows, paragraph 10. Quote kore diba. In the said judgment, reference has also been made to the case of T. Aravindanam versus so and so, reported in 1977 Salama, wherein the following has been laid down in the context of the adjudication process of an application under Order 7, Rule 11 of the CPC. Yeah, right, to me, to page 9.1 or 5 to divide. Huh? 9.1 or 5 to divide. The learned senior counsel accordingly submits that the impugned order dated 18/11/2023 is unsustainable in law and is liable to be set aside. Para. Per contra, Sri Padgiri, the learned counsel for the aforesaid respondents, has submitted that though it may be correct that in the plaint, there is no reference to the order dated 3/9/2018 of the Honorable Division Bench, there was disclosure of the proceedings before this court and also the fact of rejection of the application under Section 17, full stop. 17 of the Surfacey Act, full stop. The learned counsel has also emphasized on the issue of fraudulent practice in the transaction and has justified the approach of the plaintiffs to the learned civil court by filing the instant suit, full stop. It is contended that the issue of fraud can only be adjudicated in the proper manner by a civil court and not by the tribunal, full stop. Para. In support of his submission, the learned counsel for the respondents plaintiffs has referred to the following decisions. Okay. Number 1, 2021, 9 SCC, page 99. Number 2, 2016, 4 GLT 633, full stop. Para. In the case of Sri Hari Hanumandas Totala Supra, the Honorable Supreme Court was deciding was seized with an order whereby an application under Section 7, under Order 7, Rule 11 of the CPC was refused, and such refusal was held to be justified. Full stop. Para. In the case of Giridhari Saha Supra, this court had made certain observations on the maintainability of a civil suit in matters pertaining to the Surfacey Act, where there is apparent fraudulent, where there are serious allegations of fraud, full stop. In the said case, this court had extensively discussed the observation of the Honorable Supreme Court in the case of Mardia Chemicals Supra. Para. The learned counsel for the respondents plaintiffs has accordingly justified the order dated 18/11/2023 and has prayed for dismissal of the petition. Full stop. Para. Sri M. Sharma, learned counsel for the bank, has, however, supported the petitioner in the present case. Full stop. He has categorically denied the allegation of fraud made in the plaint and has submitted that such allegations have been made only to overcome the aspect of the bar on a civil court laid down by Section 34 of the Act. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Para. The approach to the civil court was only after the approach to this court by filing a writ petition being WPC 6015 of 2014. Full stop. It is not in dispute that the subject matter of challenge in the writ petition was the auction purchase. Full stop. The writ petition was pending before this court for a period of about 4 years and was disposed of only on 21/5/2018, in which period the respondents had enjoyed an interim protection. Full stop. The disposal of the writ petition was with a direction to the respondents to approach the DRT by filing an appropriate application under Section 17 of the Surfacey Act within a prescribed time. Full stop. However, the respondents did not file any such application within the prescribed time, and the application which was filed beyond the said prescription was rejected by the learned DRT. Full stop. The subsequent IA Civil 3157 of 2018 was also dismissed by the Honorable Division Bench on 3/9/2018, wherein serious observations, wherein the Division Bench had made serious observations on the bona fides, doubting the bona fide and lack of due diligence of the respondents. Full stop. It is only thereafter that the civil suit has been instituted on 12/10/2018. Full stop. Para. Though an allegation of suppression of material facts has been raised inasmuch as the order dated 3/9/2018 was not disclosed in the plaint, even if the aforesaid aspect is overlooked, what is apparent to note is that if there was any actual fraudulent action, there was no role played. There was no action taken by the respondents as plaintiff to bring such fraudulent activities to light before any forum. Full stop. This court has also carefully examined the pleadings, the relevant pleadings in the plaint, which is found in paragraph 7, full stop. For ready reference, comma, the aforesaid pleadings are extracted herein below, full stop, at page 25. A bare reading of the said pleadings will not bring this court to any conclusion that there has been any substantive allegation of fraud, and it appears that only to overcome the bar under section 34 of the Act of 2002, comma, such allegations have been made in terms of the exceptions carved out by the Honorable Supreme Court in the case of Mardia Chemicals. Full stop. Para. The observations made in paragraph 51 by the Honorable Supreme Court in the aforesaid case of Mardia Chemicals is an exception which is to be applied only in cases wherein there are serious allegations of fraud and not in a routine manner, as the objective of inclusion of the bar in the form of section 34 would otherwise be defeated. Full stop. Para. The so far as the aspect of adjudication of an application filed under Order 7 Rule 11 CPC is concerned, comma, the same has to be adjudicated on the basis of the averments made in the plaint itself. And when the court notices that such suit is barred by any law, comma, it would be duty of the court to reject such plaint. Full stop. In the instant case, comma, a clear bar has been made by the Surfacey Act of 2002 in the form of section 34. Full stop. This court has also noticed that the party concerned is not left remediless, and in fact, the Act of 2002 itself gives the party an opportunity to approach the DRT by invoking section 17 of the Act. Full stop. The Act in question also provides for an appeal under section 18, and the said appellate remedy to prefer an appeal is yet to be exhausted. Full stop. Para. So far as the case laws relied upon by the respondents, comma, this court has noticed that in the case of Sri Hari Hanuman Das Totala, comma, the refusal to reject the plaint was on the ground that the defendant in their petition had raised the issue of res judicata. Full stop. The Honorable Supreme Court has, however, held that such issue can be decided only in a trial and not on an ex facie reading of the averments in the plaint itself. Full stop. Therefore, the application of therefore, in the considered opinion of this court, comma, the aforesaid judgment may not come to the aid of the respondents, full stop, para. In view of the aforesaid discussions, this court is of the opinion that the impugned order dated 18/11/2023 is unsustainable in law and accordingly interfered with, full stop. The should we remand it back?
No,
This court is also of the opinion that since a case of a clear bar under section 34 of the Act of 2002 is made out, comma, the order, the application filed under order Rule 7, Order 7, Rule 11, which was registered as Ms. J case number 279 of 2023, stands allowed. Full stop. Petition accordingly stands disposed of.
Consequently, the plaint is protected.
Plaint is allowed. Oh. Allowed, leading to rejection of the plaint. Grateful.
Liberty मतलब under section 18 of the Surfacey Act.
Since this court has already observed the availability of an appellate forum under section 18 of the Act of 2002, comma, the respondents herein may avail the said remedy if remedy, full stop. However, the same may be done strictly in accordance with law.
All right.
Hello.
Yes, yes.
I found both the things. I found also a case which was transferred in criminal, because it's coming from one criminal court to the other. And I also found, I apologize. We're just getting we are just learning the corridors of the court. A lot, we apologize for this.
What is the citation?
The citation is although it's also to be adjudicated in the civil manner, because of chapter 4 of the DV Act, which is the code in itself. But we found this.
You take recourse to 407, you withdraw it?
Yes, yes, yes. Because we were not guided properly in the filing.
Doesn't matter. Heard your name?
Ezekiel.
Heard MS Ezekiel Leonard counsel for the petitioner, who by means of this application has paid for transfer of DV case number 106/2019 pending in the court of the Judicial Magistrate First Class BOCO to any appropriate court in the district of Kamrup Metro. Full stop. This case has, however, been filed under section 24 of the Code of Civil Procedure. Full stop. Para. This court is, however, of the opinion that the proceedings under the Domestic Violence Act, under which the case has been registered, being quasi-criminal in nature, comma, the appropriate provisions, appropriate statute under which such transfer petition is to be filed is the Code of Criminal Procedure 1973, full stop para. Learned counsel accordingly prays for and is prays for withdrawing the matter with liberty to file afresh in the proper manner, full stop. Petition accordingly stands dismissed on withdrawal with liberty as prayed for. Yes.
Appearing by proxy notice. The new substantial question of law has been marked as annexed X.
Items?
8.
8. What is this?
But in this case, the plaintiff booked the plaintiff who have a passport, booked some ticket, wanted to go to the Singapore. When he was about to board the flight, lordship, there is discrepancies found on the actual number and the number which is engraved in the at the first page of the passport, lordship. So he could not go, lordship. So far as 87,000 is concerned, lordship, he is entitled. That damage is calculated. That has been proved by fact and figure. The other damage is 1.5 lakh, 1,50,000. That is without any fact and figure whether that is justified. If it is a punitive damage, whether there was a contract to that that has not been satisfied. And if it is a liquidated damage, then also lordship it cannot be. At best, it can be a lordship nominal damage. So it should have been not to that tune of that 1.5 lakh.
This 1.5 is a compensation.
Compensation
For the loss.
87,000, that is a genuine claim that has been given.
87 is the loss suffered, and 1.5 is the damage he's claiming.
Damage, yes.
Damage is in the form of unliquidated damage.
Lordship, whether that was justified being lordship, that amount, lordship. With the,
If you make out a case, was there any evidence given?
No, ex parte. It was ex parte. So
You did not contest.
We could not contest. With that,
No,
thereafter we filed an appeal that was dismissed on the ground of delay, lordship.
No, if he has suffered a legal injury, why not?
For
If he
legal
suffer-
injury, he has been given 87,000.
That is not the injury. That is the only the loss.
Loss suffered.
Loss. That is not the damage.
That 1.5, that is excessive loss.
How much, according to you, should be the damage?
It should be the lordship nominal or
2.
damage has to be proved by facts and figures.
You did
Monetary claim has to be
You
proved
did
by
not
facts and figures.
contest.
Lordship,
You did not contest.
lordship, that's true.
What prevented you? Have you filed?
Lordship, that was
Have you filed a vacating ex parte?
No, we came to the first appellate court. lordship.
There is no bar. You can straight away come.
And that first appeal has been dismissed on the ground of delay, lordship. Without going to the 236 days delay.
Oh, it is not on the merits.
Not on the merit.
Oh, you are here in the second appeal on the delay condonation.
Lordship.
Admitted or not?
Not admitted.
We'll admit this then.
Only lordship, there is
But
no.
if you are agreeing to some proposal, then no point. It's only a simple.
Lordship may admit it. In the meantime, it can be sorted out, lordship.
No, his right to have a fair hearing in the first appellate court, that we cannot straight
But
away say,
there
no,
is-
he's not entitled.
There is no explanation why they have come delayed. The
We'll-
suit was filed on 27/8/2018 and made it expiry on 5/6/2019.
During the COVID period.
Not COVID. COVID started from March 2020.
Then when was
Then
the
judgment was delivered on 10/2/2022.
10-2, that was up to 28.
10 to 2020
2022. And
judgment?
yes. And they filed the appeal on 5/11/2020.
2000? Okay, there may be some delay. What is the explanation?
Explanation is such a very vague explanation, Lord.
Because change in the
There may
DSP
be-
office, lordship, that the file could
There
not
may
be
be-
placed.
Such a kindly peruse the impugn order, Lord. That has been elaborately discussed. Lord.
See, because of the explanation by the Honorable Supreme Court, he has to come up in appeal, which he has done.
Yes.
In 2005, that Shamsundar case or something, it will be an appeal. So he has filed an appeal. But to be very frank, these are not in the form, it will not, though it is in the form of appeal, it's almost like a revision. We only adjudicate whether the reasons assigned for rejecting the petition under Section 5 is proper or not.
Yes.
And you know the approach of the court, liberal approach.
Yes. That is there, but
So best is why don't you talk and settle the matter?
a small amount as the lordship is a professional lordship. He availed the passport and accordingly plan a holiday trip with his wife.
That is unfortunate.
Newly
I
married
do
wife.
admit, Lordship.
And then he come from Durhat to
I think
Guwahati.
1.5 is less.
Less lordship. So therefore only 87,000.
The amount of words he is having to hear every day.
Mental agony lordship, along with his newly married wife. He went for Singapore and Malaysia. He was brought a voting pass was issued. In the security pass, in the immigration, he was deboarded on the ground that the printable number in the passport and the printed number is to
Then wife had gone alone for the honeymoon.
No, lordship, he is also deported ultimately. The only 1.5
doubt
lakh
it's
only lordship.
1.5 is very less.
Very less lordship. And he has availed a leave also.
What do you do?
Is a
There is no
assistant
explanation,
professor
Lord.
at the Assam Agriculture University.
There is no explanation at all, lordship.
How much did you claim?
4 lakh.
4 lakhs lordship is claiming. So 87,000 is the ticket amount has been given and the 1.5 lakhs has been given as the compensation.
He
Only
has not been given, you are lucky that he has not filed any cross objection. Settle it.
Lordship, I think you can be sorted out like because he has filed an execution petition also. Lordship, there we can.
You had filed execution. Go ahead with the execution.
After filing the execution, they have come with
Come
with
for
the appeal.
first appeal.
Yes, sir. That is the difficult.
Okay. But we don't worry, once we admit, it will be unnecessarily delayed.
Yes, sir. That is the difficult. It is once the admit will is admitted, it will take another 4-5 years for a small amount.
We will fix a date. The instant appeal has been referred under section 100 of the Code of Civil Procedure against a judgment dated 7/8/2023 passed by the learned District Judge Jorhat in Ms. J case number 46 of 2022, by which for 22 in money appeal number 3 of 2022, full stop, by the aforesaid order, comma, the delay in preferring the appeal has been refused to be condoned, and consequently, the appeal has been dismissed. Full stop. The appeal was preferred against a judgment and decree dated 10/2/2022, passed by the learned
Civil Judge Jorhat.
Civil Judge Jorhat in Manisut number
41 of
2018. Full stop. Para. The appeal is admitted on the following substantial question of law. Whether the approach of the first appellate court in dismissing Ms. J case number 46 of 2022 for condemnation of delay was in accordance with law. Full stop. This court may frame any other substantial question of law at the time of hearing with notice to the parties. Full stop. Since the contesting respondent is represented by Sri S. Dekha, Learned Counsel, formal notice is dispensed with. No, issuance of formal notice is dispensed with. First, however, an extra copy of the memo of appeal be served upon Sri Dekha within 2 days. First stop. List on list on 17th of July. 17th of July for service report. Oh, no, 17th of July. Full stop. Para. Pendency of this case shall not be a bar for amicable settlement of the matter.
The endeavor, observation, endeavor shall be made.
Let them come and remember.
Safety.
And in any case, if you are insisting for any stay, we'll direct you to deposit.
Since it is a money.
Matter will unnecessarily be
Yes.
infructuous.
Yes.
So better to pay.
Item 48 time being.
Yes, what is this? Mr. Khan?
Perhaps this matter became interesting because one title suit was lost, one divorce petition was filed by the petitioner, and another restitution of conjugal life was filed by the respondent.
Okay.
Now, Lordship,
Item number?
Item number 40.
48 was called in the first hour.
My lord, sorry, Lordship, I was not there.
No,
I was in
okay.
another
Okay, you are for the petitioner.
petitioner.
Who is for the respondent? Mr. Mahanta was there, yes. Junior Mahanta was there, yes. You're for, okay, no problem, you be here. What has happened?
My lord,
You filed whom? You filed petition for?
divorce.
You are the husband?
No, I am the wife.
Petitioner wife, appellant wife, or transfer petition?
Now transfer petition against the restitution of conjugal life.
Petitioner wife filed for divorce.
My lord.
And the husband?
Husband filed a petition before the family court Kamrup for restitution of conjugal life.
Restitution.
My lord.
Then what happened?
And against that process, we filed this petition for transfer this case from Kamrup to Kukraja.
The restitution.
Well, during this period, Lordship, divorce has already taken. Parties has settled the matter, Lordship. So,
Heard. Sri M. Khan, Learned Counsel for the petitioner. Also heard, madam, what is your name?
D. Sharma.
D. Sharma. MS D. Sharma, Learned Counsel for the respondent. Full stop. Para. The instant petition has been filed under section 24. 24.
Well, 24.
24 of the Code of Civil Procedure for transferring FC civil case number 266 of 2018 from the court of the principal judge, family court number 1, Kamrup, to Kamrup M, to the learned court of the district judge, Kokrajhar. First up, the aforesaid FC civil case number 266 of 2018 was for restitution of conjugal rights. First up, Para. Sri Khan, the Learned Counsel, has however informed that the petitioner had also instituted a a proceeding for divorce under section 13 of the Hindu Marriage Act, which was allowed, and the parties have been reviewing separately since then. Full stop. the said decree of divorce has not been put to further challenge. Full stop, para. The learned counsel accordingly submits that the instant petition has become infructuous. Full stop. Para. The learned counsel for the respondents does not object to the aforesaid proposition of facts, aforesaid narration of facts, and is not opposed to the prayer made. Full stop, para. In view of the aforesaid submissions and the developments which have taken place, including grant of divorce, which has attained finality, comma, nothing remains to be adjudicated in this petition, and accordingly the same is closed. Interim order passed earlier stands vacated. 49-19. Mr. Talukdar, yes.
My lord. The order, impugn order has rightly been passed here. That is the defendant witness number 3 is not a witness only, he is a party. File written statement. And thereafter, after filing the evidence on affidavit, repeatedly reminded. So what the trial court will do? Accordingly, his evidence has been examined.
What were the facts? Just please, Mr. Jha, yes, what has happened?
Your lordship, in this case,
You are the petitioner, plaintiff.
I'm the defendant.
Defendant, okay,
Your-
petitioner. How many petitioners?
Your lordship,
Two petitioners.
plaint is at phase,
You are two petitioners.
your lordship.
You are the defendants.
I'm the defendant number 3 and 4.
3 and 4, okay. Suit was for?
It was for cancellation of the salary, my lord. My partial land has been sold by this defendant number 1 and 2 to the 3 and 4.
Of sale deed.
Your lordship, suit is for declaration or that the deed of sale, void, inoperative, and declaration of the plaintiff, title and confirmation of position for partition and permanent. This is your lordship, page 80.
Okay, then you had filed written statement.
Your lordship.
Then what did happen?
Your lordship, here is dependent number 1 and 2 of the
Yes.
plan. He is the owner. And he sold this land to me, dependent number 3 to 4.
That is your version.
No, it is a admitted position.
No, he says that
Normal. Land belongs to us.
No, land belong to him, land belong to me. This is a question to be decided in the trial. Your
yes,
lordship.
yes, what has happened now?
Now here, these 2 person, 1 and 2 is the person who sold land to me.
3 and 4.
2, 3 and 4.
Oh, yes.
Your lordship, thereafter the WS filed by me as a dependent number 3 for purchaser, and these 2 as a your lordship seller, he separately also filed the WS.
You filed separate, 3 and 4 filed the common WS.
My own WS along with contract land.
Contract claim, okay.
And this
WS
1 and 2 filed WS separately.
Right, contract claim, okay. And by one, the D 3 and 4. 4. WS filed by 1
and
2. D1 and D2, okay.
Your lordship. Out of which your registry borrow, dependent number already expired.
Okay.
So now it's come Procedural. At the time of trial, your lordship, at the time of filing of DW, evidence was filed by me as 1 and 2. This dependent number 2 filed his evidence as DW3. I filed total 5 DWs, of which 3 is the dependent number 2, 4 already expired, and 5 is an advocate.
Now see, your defendant numbers 3 and 4.
3 and
your position as a witness is what? What is the number?
my position is 1 and
Your DW1 and DW2.
your lordship. Procedural, DW3.
Defendant number 3 is DW1. Defendant number 4 is DW2. Okay. Okay. Then what had happened?
Then dependent number 2 filed DW as a DW3.
Okay, just a minute, please. D3, D4, and D2 filed as D3, DW3.
3, Your Lordship.
Okay.
So now, during your cross-examination, Your Lordship, this DW3 didn't turn,
Did not turn up.
Your Lordship. And the your order, first order, Your Lordship, page 43.
43.
Your Lord. And that cross-examination was done on the your Lordship in the commission, on commission, Your Lord.
43.
Page 43 and next 3.
16.9.
Your Lordship. Here what, Your Lordship, on the basis of the report of the commissioner, Your Lordship, entire evidence was closed. The cross-examination was fixed only for DW3 on that particular date. But learned trial court, on the report of the commission, he closed all the evidence, including DW5.
No, see, the chief of DW3 has only been expunged.
Your Lordship. So DW5 remains. But what is the order, Your Lordship? Last part, the evidence of the defendant side is closed accordingly. I have also DW5.
Did you adduce evidence to DW5?
Your Lordship, on record.
So it has not been expunged.
But Your Lordship, the evidence of the defendant side is closed.
Yes.
Case is fixed for argument.
Yes.
So what about the DW5, Your Lord?
You said that you have already adduced evidence to DW5.
No, I have adduced cross-examination part, Your Lord.
Cross-examination, there is no expunge.
My evidence, DW5 has not been expunged, but he was not cross-examined, and he may take the Your Lordship.
So why are you aggrieved?
Your Lordship, I am aggrieved by the closure of DW3 also.
That's a different matter. DW5, there is no reference to DW5.
But Your Lordship, if the cross-examination
if at all somebody has to be aggrieved, it is with the plaintiffs that you have closed the evidence of the defense without affording us to cross-examine DW5. They have not come up.
Your Lord.
But you may have a case for DW3.
DW3, I have a case for DW3.
Okay.
Because DW3, defendant number 2 sold land to me.
Yes.
Now he is not coming to the court for giving evidence, Your Lord.
Okay.
So I file an application, Your Lordship. Thereafter, I file an application under 151, praying before the court to issue summon upon the defendant number 3, DW3, and DW5.
Now, after closure, unless that is set aside, how do you pray for issuing summons?
Your Lordship, I pray for Your Lordship this recalling of the order dated.
Recalling, that is
recalling,
a different. Yes, where is the application?
Application is page 44, Your Lordship.
Before 151 petition.
Your Lordship.
Petition under section 151.
151.
Okay. What has happened thereafter?
Your Lordship, so I pray for recalling of that order, and with a prayer that someone may be issued upon DW3, even DW5 for cross-examination. That has been rejected by the order dated, Your Lordship, 18/2/2020. Page 52.
Page
52, Your
18?
52.
18/2.
18/2/22.
Page 52.
Your Lord. Your Lordship, page 56, last para Your Lordship in particular.
2008.
Your Lordship. Question 8. Your Lordship, in delaying the dispute, Your Lordship, I am not only the Your Lordship. Plaintiff is also there.
You are not only that means you are admitting that you have some rule. At least you have been fair enough.
So both are responsible for that, Your Lordship, if it is delayed.
Mr. Talukdar has not said yes.
My lord, in the recalling petition,
Just a minute, we'll come back to you. Then what is the order?
Order, Your Lordship, page 56 in particular, Your Lordship. But the three last prior, upon careful perusal of the above observations, also given pro Your Lordship, report. Your Lordship, page 55.
Instead of 8.3, the order is 18.2.
Your Lordship.
Petition rejected.
18 to 20.
There is a stay order here or what?
Your Lordship, stay order.
Stay order. Yes, any case law you would be relying upon?
Your Lordship, I am not relying upon any case law, Your Lordship. My humble submission, Your Lordship, I purchased the land, and this defendant number 2 sold land to me. And now he is not coming to the court, Your Lordship. So I will suffer. It is a substantial justice, Your Lordship, to be done, Your Lordship. Because he is not in my control, but if he didn't turn up in the court, ultimately affect me because I purchased the land and I am also the contract claim.
Your purchase is by registered sale deed.
By registered sale. And for that, Your Lordship,
What is the area of land?
3 kacha, Your Lordship.
Where? Where is the area?
Your Lordship, it is Pub Boragaon, Jalugari.
What is the price?
As of today, Your Lordship,
No, price in the sale deed.
sale deed I have not named. It is not.
And Mr. Talukdar, you claim that the sale was by fraudulent activities.
fraudulent activity.
Your Lordship.
Both are the same village. So apprehending danger, this defendant number 3, although he filed written statement, he used evidence, he tried to come to that. That's because he illegally sold the land. And moreover, my lord, that defendant number 5, he is a registered, sub-register at that time when the sale was made. So, my lord, and in the recalling petition, my colleague, the prayer portion is, my lord, at page 47. It is therefore prayed that Your Honor may be pleased to recall the order dated 16/11/19 and DW 2, 3, and 5 may be cross-examined and may be brought on record before this honorable court, and further be pleased to issue summon upon the DW 3 and DW 5 to compel their attendance before this honorable court for test cross-examination for the interest of that. Where is the provisions of PPC? There is no any provisions that anybody can compel a witness, a party. He is a party. If he did not appear, then he will face the consequences.
He is not a mad witness, he is also a party. So as far as D3 is concerned. So far as the sub-register is concerned, that's a different matter.
Different matter.
Yes, how do you react?
My humble submission, Your Lordship, regarding DW3, he is not only the party to the suit, Your Lordship, he is also the vendor. Seller to me. So, before that, Your Lordship, the one.
Suppose you issue summons.
Your Lordship.
Court issue summons.
Your
He
Lordship.
doesn't appear.
Your Lordship.
Then what would be your reaction?
Your Lordship, then he'll be the first measure may be taken to bring him on Your Lordship to the court. Because if the court has issued the summons, it is the duty of any
Coercive
citizen to
measure in the form of what?
So, Your Lordship, police or does it like
Now, under what provision? How do you secure the attendance of a witness in a civil proceeding?
By issuing summon, your lordship.
How do you secure the attendance? Summon is only a mode of calling him.
Your lordship.
How do you secure his attendance, that he has to be present? Is there?
First, your lordship, he will voluntarily come to the court on receipt of the summon. One mode of that.
No, if he doesn't come, how is there any means? What are the prescription in law to secure the attendance of a witness?
Your lordship, for that, your lordship, time will be granted. I will come up with that.
Civil courts and orders. Civil courts and orders. অপূর্ব শর্মা কিতাব।
Your lordship, landlord can now state me, section 30.
Yes, please.
Section 31 and 32, your lordship, penalty.
Yes.
Section 31. The provision of in section 27, 28, 29 shall be applied to summoning to give evidence or to produce document or other material object. Penalty for default. The court may compel the attendance of any persons to whom the summon has been issued under section 30, your lordship. And for that purpose may issue warrant for his arrest. He can be compelled by issuing warrant, your lord. And attest the and tell his book. Impose fine upon him and order him to furnish security for his appearance, in default committing him to the civil. So the evident procedure is there. By humble submission, and before that, your lordship, one of the submission made by learned friend, your lordship, regarding the illegally selling of the land. In fact, the mayor his plaint may be read, your lordship. He pray for his right as well as partition of the land. The fact is that my vendor and his, they all are from the same family, your lordship. It is joint property. My case is that joint property is already divided in between the parties, and from the vendor from his, they are sold to me. Now he come up with the case saying that it is my land and also praying for partition of the land. A specific prayer is there, your lordship.
We will not go to the merits of the.
So this is the submission.
Yes, Mr. Talto, what do you say?
My lord, this provision is 31 and 30 with respect of witness. My question is this: if DW3 himself is a party, if he did not appear before the court, then consequences he will face.
No, we cannot see. You cannot force a party to defend its case. It's up to him.
Yes,
but once he is cited as a witness.
Party, how it can be cited?
The party can be a party. Parties are witness. Parties are the best witness.
Yes, in that sense,
now DW3 may not be adducing evidence for his behalf or for his benefit, but his evidence may be important for Mr. Jha.
But in the list of witness, he has not cited that DW3 list of witness.
But he already filed evidence, your lord.
Examination chief filed, but at the time of cross-examination, he remained absent.
See, this matter is pending since quite long.
Long back.
Why don't you agree upon something? We may allow this petition with obviously some cost. But unfortunately, the DW3 is not here. Cost to be imposed upon whom?
Yes, he is not present.
No, we don't want matter to be pending, and either it's benefiting you nor to him.
Yes.
And we will clarify that though this DW3 is one of the defendant, but this order would be only in the context of treating him as a witness.
Yes.
And he'll take steps for issuing summons, and within a particular date, he would appear. If not, court will take recourse under the law.
Definitely.
And so far as 5,
Your Lordship, I pray for that. His advocate, he come, Your Lord.
who is 5?
I was a testing witness of the sale.
But has he filed his chief?
It was bad. It is on record.
But that will be an abundant caution, because the impugned order does not say anything about DW5.
About, Your Lordship.
The instant petition has been filed under Article 227 of the Constitution of India against orders dated 16/9/2019, passed by the learned Civil Judge number 1, Kamrup M. Guwahati, in title suit number 56 of 2008 and dated 18/2/2022 in petition number 5316 of 2019, arising in the said title suit. Full stop. The petitioners herein are the defendant numbers 3 and 4 in the said title suit, which was instituted for, amongst others, cancellation of a sale deed. Full stop. Para. I've heard Sri Anand Jha, learned counsel for the petitioners, whereas the respondent numbers 1 to 1-3 is represented by Sri B.C. Talukdar. Full stop. Para. Sri Jha, the learned counsel for the petitioners, has submitted that his clients who have been arrayed as defendant numbers 3 and 4 had filed written statement in the suit, and similar written statement is also filed by the defendant numbers 1 and 2. Full stop. As per the petitioners, as per the projected case of the petitioners herein, comma, the plot in question was purchased by them from the defendant numbers 1 and 2. Full stop. Though the present petitioners had filed their evidence by way of affidavit, comma, it transpires that the defendant number 2, who had adduced evidence as DW3, could not present himself for cross-examination. Full stop. Accordingly, comma, the learned court below vide the order dated 16/9/2019 had expunged the evidence of DW3 and and also closed the evidence of the defendants. Full stop. Sri Jha, the learned counsel has, however, clarified that though there is no reference to the evidence of DW5, comma, even the said DW5 was yet to be cross-examined, and therefore, in all probability, comma, the evidence of DW5 would also be treated to be expunged by closure of the evidence of the defendants. Full stop. Para. To rectify the aforesaid lacuna, comma, the present petitioners had filed a petition on 16/11/2019 under section 151 of the CPC, which was numbered as petition number 5316 of 2019. Full stop. However, comma, by the subsequent impugned order dated 18/2/2022, the said petition has also been rejected. Full stop. The learned counsel for the petitioners submits that the evidence of DW3 would be vital to establish the case projected by the defendant numbers 3 and 4, as the said DW3 was one of the vendors from whom the land in question was purchased by the registered sale deed. Full stop. The learned counsel has also submitted that in dismissing the petition by the order dated 18/2/2022, comma, the learned court had failed to exercise jurisdiction conferred by law, and by which grave prejudice has been caused to the petitioners, and there would be miscarriage of justice in the adjudication process. Full stop. Para. Sri Talukdar, the learned counsel for the respondent number
1 and
1 and
2.
1 and 2,
Yes.
1, 2 and 3.
120.
1, 2 and 3, who are the plaintiffs, has however submitted that the suit is of the year 2008 and has been dragged for all these years. Full stop. By referring to the order dated 16/9/2019, comma, the learned counsel has submitted that the same would reflect that in spite of adequate opportunities, comma, the DW3 did not present himself for cross-examination, only to delay the proceedings. Full stop. It is also submitted that the said DW3, apart from being a witness was also the defendant number 2 in the suit, and therefore his position cannot be equated with that of a witness per se. Full stop. He further submits that a defendant cannot be forced to contest the proceedings if he chooses not to do so in spite of receipt of notice. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. This court has noticed that the suit is of the year 2008, and in this present case before this court, there is an interim order for which the suit has not been able to be proceeded further. Full stop. Para. The contention made on behalf of the petitioners regarding the importance of the evidence of DW3 and DW5 cannot be overlooked, inasmuch as it is DW3 is one of the vendors from whom the land was alleged to be purchased, and DW5 was one of the witnesses in the said transaction. Full stop. Though the order dated 16/9/2019 had only expunged the chief examination of DW3, closure of the defense witness may in all likelihood would be construed that the witness, that the evidence of DW5 would also not be considered, as he was yet to be cross-examined. Full stop. Para. This court has also been apprised of the provisions in the Code of Civil Procedure regarding summons to witness and the penalty for default, as laid down in sections 31 and 32 of the said code, COD. It is seen that in an appropriate case, the court may compel the attendance of any person
Yes, section 30, your lordship.
30 is not a witness. That is what we are.
Your lordship, then your lordship, order 16, rule 40.
Order 16?
Rule 40.
That provision of 32 is only when the court requires that some attendance, not for witnesses. Order 16?
Rule 14. Subject to the provision of this code as to attendance and appearance and to pay law for the time being enforced when the court at any time think it necessary to examine any person including the party to the suit and not call as a witness by a party to the suit. The court may of its own motion.
This will not come. This will not come into. This is the court's discretion. Now this DW3 and DW5 on their own volition, on your they have given witness evidence. They are not witnesses to be
Your Lordship,
understood in the
in particular, defendant number 5, the given witness as my witness. Defendant number 3, 2, given as a TW3.
We are giving you a chance, but we cannot have it recorded in our order that the court may take the recourse of 31, 32. That will not be proper. Pastor, can you please listen? No, court may.
Your Lordship, section 30, I may read again, Your Lordship. Subject to such conditions and limitations as may be prescribed, the court may at any time either of its own motion or an application of any party. So I am the party, I file an application, Your Lordship.
No, if the case would have been that you want the attendance, the witness of a person who is not under your control.
Your Lordship.
You pray for a summon. Summon will be issued. If it doesn't attend, consequences will follow. Now here is a witness who has adduced evidence on your behalf at your behest.
Your Lordship.
And thereafter he has failed to come.
But you also one thing.
We'll just make a observation. We'll not enter into those cases. No. Court may issue summons by taking recourse to section 31. Full stop. In the instant case, the petitioners may also apply to the learned court for issuance of summons to the witnesses, to the concerned witnesses, namely DW3 and DW5, in case they are not being able to be produced by the present petitioners on a date fixed by the court. Full stop. Considering the above, this court is of the this court is of the opinion that interest of justice would be served if the petitioners are given an opportunity to pray for issuance of summons to the respective witness, namely DW3 and DW5. Full stop. The impugned orders dated 16/9/2019 and 18/2/2022 passed by the learned so-and-so court accordingly stands interfered with. Full stop. The petitioner is directed to file necessary application for issuance of summons to DW3 and DW5 within a period of
Date may fix it.
within on or before. We give 10 days, Mr. Taludar. 10 days. Within on or before. On or before 19th of June. Okay, Wednesday, 19th of June 2024. Full stop. Such application, such application, however, is not to be entertained if it is not made within the times prescribed. And the full stop. The stay order passed in this proceeding is also vacated to enable the proceeding to be completed expeditiously, as the suit itself is of the year 2008.
application to be filed on and before your order.
On or before? Oh. What are they going? Oh. আছে নেকি ticket? কোনটো আছিলে? Does not matter, part had matter, yesterday's matter. What will happen? আজি তো নহব চাই কাইলে কৰিব লাগিব। It may not be possible today. We got আগতে ক'ব লাগিছিল শেষ কৰি দিলো সেইটো। We'll have it on another date. Next Tuesday. Tomorrow it may not be possible. Okay. Paucity of time did not list on as agreed to by the party list on Tuesday next.
Okay.
Yes, any important matters in the orders? Control for us. 15, yes. Let us have 15. Yes, 13 matter. Yes, why not? What is this?
Final 174 delay for substitution of the defendant, my lord.
You are for the defendant.
My lord, I am for the appellant, my lord. Defendant number 1 died.
Appellant is the plaintiff. You are the plaintiff.
I was the defendant.
That is your substitution.
In the trial court.
Okay.
And now the appellant in the.
You are the appellant defendant.
Appellant.
The original appellant had passed away. Okay.
On 18/8/2012.
Okay. And there was delay in substitution.
Yes, 174 days, my lord.
Was it abated?
Not abated, my lord.
Abated. There is the order you lost to kindly see. Order dated me not 21/7/2014.
Have you filed for setting aside abatement?
No. Yes, I have already filed, my lord.
Huh? No. Where is your application for setting
my
aside?
lord? 1576.
1576.
Yes.
Mr. Mr. Talukdar, have you seen the order passed on the earlier proceeding? Appeal abated automatically consequent to the death of respondent number 1. No application for setting aside abatement has been filed, although leave was granted. The office shall not list the appeal again unless and until application for setting aside abatement is filed.
My lord, that is why I filed, my lord, this.
Where?
This 1576.
1576 is the order passed here in 1576. And this order was passed almost 10 years back.
21/7/2014.
21/7/2014. 10 years you did not take steps for setting aside abatement.
This case number 1576.
And there is an order not to be listed unless you file an application for abatement. Why has it been listed? লিস্ট কিয় কৰিলে এইটো? লিস্ট কিয় কৰিলে? This office shall not list this appeal again unless and until application for setting aside abatement is filed. Your appeal has been abated.
Yes.
You can sleep peacefully. 10 years you have slept, now sleep. Or suddenly you have woke up from after 10 years. It is not 10 years, 1 more month. We cannot pass any orders, Mr. There's an observation not to be listed unless you file at setting aside abatement. Heard 3 I8 Talukdar, Learned Counsel for the applicant Also heard Sri A. Ruchid, learned counsel for the respondent, full stop, para. In this mixed case, there is an order dated 21/7/2014, wherein observation has been made that the connected appeal stood abated and no leave, no application for setting aside abatement has been passed. Full stop. It was further observed that the matter was not to be listed unless such application for setting aside abatement was filed. Full stop, para. It is not understood as to how this matter has been listed in spite of such clear direction. Full stop, para. The appeal accordingly. For the sake of clarity, the order dated 21/7/2014 is extracted here and below. Full stop. The appeal having been abated, comma, the same be filed. Okay. What? Yes. Item?
Item 16.
Yes.
Lordship, can you taken down the IAL 1473 of 2016 for condonation of delay of 75 days in preparing the second appeal?
Etu ki ase 1752 to ki asile purichile neki নহলে এনেকে লিস্ট কৰিব না 1752 to so for no. Yes, what is this, madam?
Lordship, IS Civil 1473 of 2016, Lordship, this is for condonation of delay of preparing the second appeal. Lordship, 75 days delay service complete.
It is pending since 16. Why?
Yes, because of non-completion of the service, Lordship, upon the response. Now it's complete.
We are appearing for respondent number 1.
3 respondents are there.
Yeah, yes.
How many days delay?
75 days.
We condone this.
Yes.
You are vehemently objecting. You are not objecting.
Lordship, as
No, we have not understood. We don't understand sign language.
Lordship,
Objecting or not objecting?
fine. 75 days.
That we know.
Yes, sir.
Objecting or not objecting?
Sir, Lordship, objection is there, but we won't find that.
She has threatened you or what? No. Okay. Heard. Miss P. Bhattacharjee, learned counsel for the appellant, who by means of this application filed under, which is this IA?
Is 147.
Under section 5 of the Limitation Act 1961 has prayed for condonation of delay of 75 days in preferring the connected second appeal. Full stop. Though this petition was filed in the year 2016, due to non-completion of service upon the respondents, the same is pending, full stop. However, the respondents numbers 1, 2, and 3 have now been served and are represented by Miss, what is your name?
D. Swami, on behalf of Mr. D. Kalita.
By Ms. G. Swami, learned counsel appearing on instruction of Sri D. Kolita. Learned counsel, full stop, para. Ms. Bhattacharjee, the learned counsel, by drawing the attention of the court to the averments made in paragraphs
3, 4, and 5.
four and five, has submitted that there were sufficient grounds for not being able to prefer the appeal on time, and therefore and the delay has occurred not because of any negligence or laches. Full stop para. The learned counsel for the respondents has, however, submitted that the delay has not been properly explained, and accordingly the petition application be dismissed. Full stop para. An application for condonation of delay is to be considered in a pragmatic and justice-oriented approach. Full stop. In the instant case, apart from the fact, and in the instant case, this court has noticed that the delay has been explained in the petition. Full stop. Para. Considering the facts and circumstances and in the interest of justice, comma, the delay in filing the connected appeal is condoned. Full stop. I accordingly stands allowed. In the appeal, you write, in view of the order passed today, that is so and so, whereby the delay in preferring the appeal has been condoned, comma, the appeal may be registered.
No,
Appeal may
not
be
listed.
registered and be listed for admission in its turn. Okay, rest will give dates. Mr. Jain, you have been waiting for long. Which matter was yours? Item number 38. 38.
Yes.
We'll have some other date.
Maybe, madam. 39 and 41.
39 and 41.
Yeah.
What are these matters?
These are condonation of delay of 365 days against the order passed in Workmen Compensation Act.
Okay. You are for the claimant.
I was contacted.
You are filing for enhancement.
And
We'll have it on some other day. Rest also where matters needs immediate consideration, please. Inform our court master, will give dates. Next week. Mr. Mahmood, give dates.
47. I think 47.
Whichever.
Next week.
Any matters where interim order is still restricted till today, we need to extend.
my lord, 12th of this, along with another matter, similar matter, my lord. Yes.
Item number?
It is not listed.
Okay,
today,
please
but
give give the number to court master, will list it accordingly. Huh?
Item number 44, my lord, the date may be.
He'll give dates, don't worry.